Bangalore, ठीक है Bela Garu.
This is the death certificate.
Yeah, page 17.
You were intimated when?
Yes, I was intimated much later. I was intimated in 17th of April. He informed me the fact of death. So that was informed us on page 19 on 19th of May. Who are the legal heirs? And then we said, please give the address. So these are all correspondences were going on. The last correspondence is at page 21, by which I get the address as well as the names of the heirs. So
Page
21. This is the final information. And yes, this is the final information I get from the advocate of.
This is defendant.
Yes, the defendant's legal heirs now today. The defendant's legal heirs, Mr. Lal. So this information came on the 20th of May.
So defendant number 2, that is?
Defendant 1.
Defendant number 1, that is Shama Prasad.
Yes, he died.
Yes, recorded. For the plaintiff number 1 receiver.
This is number 2.
Plaintiff number 2 receiver is present in GA 2005 for recording the death of defendant number 1, Shama Prasad Mukherjee. Stop. That it took place on 26/2/2025, and thereafter the later on the lawyer of the plaintiff, lawyer of plaintiff
Was in
receiver, plaintiff receiver was by the lawyer of the deceased defendant about the death on 17/4/2025. Stop. Thereafter, the steps were taken to obtain the names of the legal heirs of the deceased defendant.
As well as the address. Page 21.
As well as the address. Sufficient cause is shown to condone the delay. Thus, delay is condoned. And the pair of the receiver, plaintiff number 2 stroke receiver is allowed. Let there be an order in terms of prayer A, B,
C and D.
C and D of notice of motion dated 16th.
Is master summons.
The master summons dated 16th day of June 2025 be passed.
Disposed of.
Let there be an order in terms of prayer
Yes.
A, B, C and D of the master summons dated 16th day of June 2025. 18 of 2025 stands disposed. So anyway, take steps and thereafter amend.
Yes. We have to amend it.
Yes.
Re-verify. Oh, Lordship will kindly record that the amendment. Sorry. Hey, but the summon timeline. Lordship has recorded.
If there is no timeline, it is 2 weeks. Yes. If there is no, if you are unable to carry it out, I shall extend it. From the date of communication.
Lordship, we can make it.
If you are unable to do it, I shall extend that.
Okay, under the rules, it is 2 weeks. Oblige. Oblige.
So you could not carry out the amendment. This is an extension of time. Carry out the amendment. Okay. So substitution was allowed. And accordingly, the other prayers were also allowed. So now this is for this is with regard to majority. complete. This J2 is to be heard out. Okay. The prayer of learned advocate matter stands adjourned till 1/7/2025. Let the service be complete. Service is complete.
This is where that the original defendant has died.
No, that is already disposed. That substitution. Oh, regarding plaintiffs. So this is for substitution of the sole defendant.
Who defended the document about that? 29th of
Sole defendant, that application is allowed. Now this is
application is but there are certain that certified copy.
that J3 should apply. Now J2 was appearing. Yes. So which application? Oh, this application is adjourned. No, this application I am adjourning it for 1 week. So you mentioned that it will appear the J3.
Item number 3.
Lord, I am
for the plaintiff degree holder.
the Commissioner of Partition, my lord. Last order of your lordship has been complied with. My lord. Lord, everything has been done. Only left the remuneration of the Commissioner of Partition, my lord, for last 16 years.
Last occasion there was a direction to pay this. That is
That
paid.
has been paid. Yes. And order has been
So
complied.
copy has been served. Copy of this.
Yes, 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 yes.
Yes. May sir. Now today. Yes, today is fixed for this commissioner's report.
My lord.
Yes, sir.
Remuneration due for last 16 years, my lord. Partly paid.
The last order, my lord, a wall required to be dismantled and a portion, common passage was required to be open to sky. Parties
Commissioner is not.
Yes.
parties sat together, they have come to a settlement that at a near future date it will be done. There is no dispute about it.
You have filed that terms.
Yes, that is recorded and they have signed also. That is the part of the minutes. So no one can, my lord, depart from it. So far as our execution application is concerned and the partition by meets and bound, it is done. Only thing is that I have paid certain amount in excess than that of the defendant, degree holder, the judgment debtor. So after the remuneration of my land commissioner of partition, so the deeds and other documents that is to be required to be handed over. Now the other part regarding the remuneration of my learned friend.
May your lordship kindly
regarding
read the order dated Justice
Commissioner of
October
Petition. May I, my lord, indicate one thing. He was appointed by preliminary decree as a Commissioner of Partition. My lord, in our High Court, at least my 26 years of practice, my lord, there is a difference between a receiver, a Commissioner of Partition, and a special officer. A special officer is given a specific job to do. A Commissioner of Partition is a specific job for partitioning the property by meets and bounds by lots. Here there are only one property, it is named two, only 2 parts. 1/4, my part, plaintiff's part, 3/4 is the defendant judgment debtor's part. So that is done. My learned friend has done it. That job he has done. Till date, we have paid 2 lakhs
No. Let us ascertain what was the direction regarding that.
from time to time. May I?
How-
indicate?
how-
May-
can-
may I-
my lord,
may I
kindly
indicate-
read
may
the
I
order.
indicate- No, no, may
My lord,
I
kindly
indicate?
read the order dated Justice
May I
October
indicate? Order goes.
Yeah, at the time of appointment, what
At the
was-
time of
what was the
appointment,
direction issued?
every time ad hoc payment was directed
Yes.
And we paid from time to time. Sometimes the judgment, the defendants did not pay. We paid from our part.
When you were appointed,
My lord, in
By
the
the
year
preliminary degree?
2010, my lord.
2010, let
Early
us see the
2000.
order.
14 July 2010.
Yes.
That is part of my execution.
Then you do one thing, collect all the orders, okay? Submit a statement regarding the orders which were passed regarding the remuneration, okay? And the remuneration CV you have
But that has been done, my lord. That has been done. That has been adjusted,
No,
my
no,
lord. Which has been paid, my lord.
What is my lord
some
saying?
series of orders by which there was a direction to pay remuneration. Let all those orders be produced, and in accordance with those orders, how much they have paid and how much they
My lord, that has been done. That has been done. My bill has been made.
No, no,
as per
I've got your
order
point. I've
dated
got your
Justice
point.
Ajay Mukherjee. As per-
let me go through the orders. Thereafter, I
Yes,
can
yes, yes.
decide as to how much is due and
Absolutely,
payable.
absolutely right.
Okay, you come with the series of orders. They are passed regarding your remuneration.
Regarding the remuneration, altogether 5-6 orders are there. Regarding specific order for payment of.
Yes.
By virtue of those orders, we paid from time to time.
Okay.
So, my lord, we'll look into those
The
orders.
last order, this is 10 June 2025, payment is made.
Yes.
That day itself.
My lord, kindly 12th
So-
April 2024, my lord.
It would be,
The
my
order
lord,
of justice-
my lord, give me only 2 days.
Apurva Sinha.
2 days time. I'll just make the compilation, make a photocopy and make the compilation.
Okay, now regarding this Justice Sinarai,
Yes.
did you comply regarding
Yes.
payment of one
No, my lord. No, my lord. No, my lord. No, my lord. 3 lakh
So the
has
rest of rupees they have
partly
paid.
paid. 2 lakhs. Out
No,
of
no, no, no.
386.
Degree holder is directed to pay sum of rupees
3 lakh.
1 lakh, 1 lakh.
Yes, we have paid.
That
it.
has been paid.
We have paid.
That is out of 3,86,000, my lord. The earlier
That
paragraph,
I shall consider, okay.
the earlier paragraph, your lordships.
Learned, for the plaintiff and learned partition commissioner are present. Learned partition commissioner has complied with the order dated 10 June 2025 and submitted the report. Submitted by the learned advocate for the plaintiff. Sittings were held by learned commissioner and the parties came to a findings and it is recorded in the said minutes by the learned commissioner. So, let the report submitted by the commissioner be kept with the record. Is further submitted by the learned commissioner that some amount is due and payable. It is disputed by the learned advocate for the plaintiff. Thus, learned commissioner and the learned advocate for the plaintiff is granted opportunity to produce the series of orders passed by this remuneration to the learned commissioner and the statements showing payment of the same. But learned partition commissioner shall also come with regard to the amount due and payable and the amount which he has received. Let this matter
Take statement. Everything is there in the file. Only we need to do the ministerial job of making
let
photocopy
this
and make the
matter
compilation.
appear on
Any day in the next week, subject to lordship's one. Third month.
July 7, 2025.
My lord, so far defendants are concerned, judgment letters, they have agreed to pay.
Yes,
That
yes.
is-
We
They
also-
have written a letter to me and in
No,
the
no,
meeting
no.
also they have conceded, my lord.
They are agreed
Now
to
the
pay
court
as per the
concerned,
order of the court.
how much how much the parties are required to pay and how much they have paid.
But in the order itself, Justice Apurva Sinha, it was this my lord, issues has been
As far as direction is concerned, it is a specific 1 lakh. Okay. Now let us ascertain how much
1
is
lakh
paid.
out of 386. 386.
But the figure
No,
of
no,
386, that I am
3 lakh
disputing.
86,000 paid 1 lakh. Only
Strongly,
part.
I am
No
strongly
exception took place. No.
remuneration, monthly remuneration. That
Those submission. Okay. 3 lakh 80,000. This is not the findings of the court. The direction of the court is 1 lakh. Thereafter, it will be decided how much is due and payable.
this much I can assure before your lordship. Whatever will be falling from your lordship, I am ready to pay.
And you can do one thing. It's better in the meantime, the parties and their learned advocates sit with the partition commissioner.
We sat
Let him-
together, my
let him
learned,
say-
my
let him
learned
topic
There are
friends
two
on-
suit premises
my
just
learned-
opposite to Calcutta Medical College.
my learned
I am the
friends'
custodian of the two
conception,
suit premises
that
and the
conception is
original
required to be
title
clarified.
documents, my lord, with me. my
Because the
lord.
monthly remuneration.
No, I shall consider what were the orders passed.
Absolutely, my lord.
From the time of appointment.
Only this should not be a precedence for the future to come, my lord. That should.
ওই
my-
হাতে লেখা কপিটা আমায় দিয়ে দিন, স্যার।
But I appear for the decree holder in this matter. Lordship, item number first one for the petitioner.
হ্যাঁ ওটা দিয়ে এইটা এটা
Lordship, Lordship, my senior has his legs in court number 25. Kindly give a short pass.
এই কপি
From the last of
My lord, the direction was for the receiver to visit and hand up the position of the other 5 rooms. 461 to kindly takes my lord's last order of 10th of June 2025. এটা অন্য মামলা বাবা My lord, I would be seeking police assistance order, my lord, now, because despite your lordship's order and despite the decree, my lord, the order is not being implemented. Lordship was very kind.
The direction.
My lord, kindly comes to 10th of June order. Before that, my lord, there is a previous order. Kindly come to my lord 6th of May order.
Yes. Yes.
My lord, kindly,
For the judgment date, yes.
my lord, kindly comes to my lord the 6th May order once, my lord.
No, I shall consider, yes, because I shall go by the previous order. What
Then,
is the direction?
then 10th of June, my lord, is the last order. My lord, paragraph 4. It appears from the report that in terms of the order dated 6th May 25, possession of the first floor of the suit property is handed over to the decree holder. However, it is submitted by receiver that some articles are there in the first floor which are to be removed. Thus, the judgment debtor is granted an opportunity to remove the articles from the first floor and make it entirely vacant. This part has been done now, my lord. So, first floor, my lord, it has been made vacant. Now, next, my lord, para 6. Affidavit filed by the judgment debtor reflects that additional director of health services has been intimated by, it should be letter, dated 21st May 2025 with regard to removal of radio diagnostic equipments. My lord, apropos this paragraph, if your lordship takes the affidavit once, my lord, the letter which was shown to your lordship, it does not even have an acknowledgement. The fact that this letter was served on the addressee being the Health and Family Welfare Department, lordship, this will not appear from the letter which has been disclosed with the affidavit. Next, however, no step is taken by additional director of health services. So if he has not received the letter, there is no question of, my lord, him taking steps. As it appears from the report of the learned receiver, that in the 3 rooms on the ground floor, there are diagnostic instruments, but other 5 rooms, there are no such instruments for medical diagnosis. Thus, judgment debtor is granted opportunity to make the 5 rooms vacant where there are no instruments lying for the purpose medical and pathological test. So, my lord, out of the 8 rooms in the ground floor, lordship was kind enough to give them some more time with regard to the permission in respect of 3 rooms, but with regard to the rest 5 rooms, lordship directed that these 5 rooms will be made vacant and handed over. And accordingly, in para 8, lordship had given the direction. Receiver shall visit the suit property within a period of 10 days upon notice to both judgment debtor and decree holder, and judgment debtor shall within this period of 10 days or within such date to be intimated to the receiver, clear all the 5 rooms which are occupied by some furniture other than the rooms where the instruments for medical and pathological tests are lying. Receiver, upon fixing a date, shall take steps to see that the 5 rooms on the ground floor are vacated and the first floor where some furniture are lying are also cleared. My lord, first floor has been cleared. That's my instruction. My lord, ground floor, these 5 rooms, today, my lord, after the decree and after your lordship's order, Initially, the report did not suggest any doctors, my lord, visiting the property. Now, my lord, the report says even doctors are, my lord, sitting in these 5 rooms.
Let me see the report of the receiver.
Kindly seize, my lord, the report which has been filed today, and if I get a copy, my lord, I can assist your lordship.
Yes, sir, please.
I have it. I have it. Paragraph 6, lordship, straight away comes to paragraph 6 of the report. I came to the ground floor of the suit premises to see whether the 5 rooms are vacated or not. But while visiting the ground floor, it appeared that the 5 rooms are still occupied with tables, chairs, patient beds, air conditioners, water basin, fans and lights. It is also observed, kindly marks this, my lord. It is also observed that 2 doctors are running their chambers in those 5 rooms. My lord, this is, my lord, unheard of. After a decree of eviction, my lord, there being no challenge, decree being, my lord, attained finality. Doctors are, my lord, in the room, patients are still visiting the doctors. So a person who is in unauthorized occupation suffers a decree, continues, my lord, not to vacate the property and run its business, my lord, therefrom. This is, my lord, not permissible according to.
One
It
of
is
the
also
5
found,
rooms, there is a USB machine.
which is still in running condition. So, my lord, the situation is like this. Out of the 5 rooms in the ground floor,
Total rooms in the ground floor are how much?
8.
So there was directions that except 3 rooms,
Yes.
with regard to other 5 rooms, it should be vacated.
Yes.
So neither of the 8 rooms are vacated.
Neither. And in these 5 rooms, my lord, I'm sorry for the interjection, my lord. In the 5 rooms, my lord, 3 rooms are being occupied, 2 by doctors and patients, 1 for an USG machine. And this is despite your lordship's order. I insist, my lord, kindly gives the receiver police protection so that these things can be removed, kept in a separate place, and my lord, property be vacated.
Yes,
And
now let me hear the judgment letter. Yes.
my lord, one last submission, my lord. Regarding those 3 rooms out of the 8 rooms, an impression was given to your lordship that some kind of a permission is required from the government because we were running a pathological or a diagnostic center. And lordship was very kind from April to give them that time. The letter which has been shown to your lordship, my lord, kindly takes, my lord, one affidavit which they have filed of 9th of June 2025. Kalyan Kumar Ghosh. There is one affidavit of Kalyan Kumar Ghosh dated 9th June 2025. একটু জজ সাহেবকে দেবেন ওটা 9th June 2025 affidavit of Kalyan Kumar Ghosh. My lord, kindly comes to page 6, my lord. My lord, this is the so-called letter of the advocate representing the judgment debtor addressed to the Additional Director of Health Services, Health and Family Welfare. And the content is, it is to inform that my client Midland, as per order given by Justice, my lord, order wants to dismantle the radio diagnostic equipment and shift thereof from premises of Midland, as per order passed by so-and-so. There is no, my lord, reference of any permission that is required from this authority. The submission which was made by the council on the other day was that, my lord, unless there is a permission from the authority, I cannot, my lord, remove. The letter is not, my lord, there is no acknowledgement on the letter. There is no track report.
The order was enclosed.
No, but see, my lord, kindly sees the.
In a annex High Court order.
Yes, order is there. But can your lordship, my lord, if I may ask this question to myself.
See the order. Necessary application. So 3 rooms are not being used. But with regard to the 5 rooms which are to be vacated, they are now being used by the doctors. Okay. Yes, now.
Medical equipment.
Medical equipment.
And my lord, X-ray room.
And the other 5 rooms? No, there is no mention in your report. You have stated, no, you just see, this is the present report. We are stating that.
However, it is found that in one of the 5 rooms,
No, 8 rooms are under their possession. Okay. Now, 2 doctors are running their chambers in those 5 rooms. So, their doctors are 2, the rooms are 5. Okay. So, these 2 doctors cannot use 5 rooms. So, which rooms are being used by these 2 doctors? You just ascertain which rooms. Because 2 doctors, maximum 2 rooms. Okay, the rest 3.
They're using as office, and my lord, they're making tea. My lord, I have annexed the photograph, my lord.
So let me see. Okay, this is the annexure A.
My,
Annexure A, this is the common space.
my lord, there are some other one room, my
This
lord,
is the second one is the
chamber.
doctor's chamber. Yes.
Third one is, my lord, they are making teas, and my lord, one using mentioning is found, my lord. That is, my lord,
No, this is 1, 2, 3, 3. No, 3 is they are making tea.
yes, my lord.
Number 4.
My lord,
No, this is 5. You are this is 5 means
my lord, the closed room is using by the doctor, my lord. So, my lord, I couldn't.
because
Sir,
you,
my
you
lord.
see just you see there is you see doctors are using one room, each doctor one room for checking the patient. Okay, that is there. Now apart from these 2 rooms, there are total how many? 8 rooms. 8 rooms in the ground floor. 8 rooms. So 2 doctors must be using 2 rooms. Okay.
That point of time.
No. How many doctors are using these rooms? Obtain a specific report. Suppose Dr. X and Dr. Y are using 2 rooms. What about the other 2 rooms? Which doctors are using these other 5 rooms? Other 3 rooms? Obtain a specific individual.
But possibly that would be difficult because the receiver is making a visit on a particular date. On her visit, she found that 2 rooms are occupied by 2 doctors and patient.
But you just inquire from them, from the directors. How many doctors are occupying the room? Suppose 2 doctors will require maximum 2 rooms. Why is all these rooms?
My lord,
And
the
USG
question-
machine, how many? Which room?
This machine one room, X-ray machine is one, and my lord, blood collection room is one. 3 rooms are being used medically.
My lord kindly considers this. Lordship is, my lord, executing a decree of eviction. My lord, whether it is 1 doctor, 2 doctor, or 5 doctors, whether it is.
Slowly, we have to go slowly. You see, one by one.
My lord, I have been waiting for
doctors are not-
5 years, my lord, for my own property. My lord, it's
No, this
painful, my lord,
executing-
for a landlord today to have a decree executed, my lord.
This is 2024, okay?
Yeah, but
Your part of the decree is complied. You have obtained part possession.
my lord, I am entitled to under the decree for the entire property.
But you see, this is not the same with regard to other properties. This was a hospital. It will take some
My lord,
time.
it's not a hospital, my lord. My lord, an impression is being given to your
What
lordship.
will the doc? You see, it was a hospital. Patients were being treated.
My lord, it is not the, my lord, landlord's concern. It is not even the court's concern. With deepest of respect and humility, I am saying this, my lord. My lord, it's like a clinic. It's like a clinic where, my lord, patients go to the doctors.
You see, earlier you see Midland Hospital doctors were treated. There were
My lord,
operations
maybe
also.
today once, my lord, Midland has suffered a decree of eviction. I am as a landlord not really concerned what is being done, my lord, there.
Let the receiver specify. Okay, one by one it will be vacated. Now, yes, what do you say?
Public so far as the cost that has been taken possession. Throughout the proceedings, our submission was that but for which I have to dismantle, there is no environmental excuses. I could have myself dismantled all the equipment are there. But there are certain conditions and
Now, very well. Now, question is, suppose the permission is required. So, after obtaining the permission, you can dismantle. But what about the rooms which are not being used by the doctors and the
No, it has not.
no, ground floor?
Ground floor on a last location. But no activity is being carried out, which is why your lordships have given us the direction and submit another representation. We have also done. Your 10th June, the order was passed, but we have again communicated to the additional director. The timing director on assistance so that we can hand over.
Now, how many doctors are running those chambers? Only 2 doctors.
So give me the balance room.
So, question is 2 doctors may maximum require because some appointments may have been given earlier. So, 2 doctors will require maximum 2 rooms. How many equipments are there? So, actually, now the thing is let the doctor run the clinic, let this testing be done from some other places, because you see, there is no emergency operation and all these things, only OPD. Okay, 2 doctors are running, not more than 2 doctors. Okay.
But your lordships will also then direct the addition of
My lord, let him first show under which law, my lord, this
How many rooms are
permission is
How
required.
many, you see, how many rooms are without other than doctors' chambers and medical instruments?
Medical instrument is my lord, 3 rooms. There.
2 rooms are by the doctor.
Yes, my lord. But others have no. There are no.
Now
Only
you
patient
see.
chairs, tables, AC, this.
Yes,
Nothing.
that is why you see here.
Yes, my
That
lord.
means that is why I wanted to ascertain, you see. So there are 2 doctors, definitely there will be 2 doctors room. Okay. Now there are rooms where instruments are kept, for which according to them they have sought permission. That is 3 rooms. 3 rooms. That means how much it comes? 3 plus 2, 5. So according to you, 3 rooms are running vacant. So you just identify on the next day which 3 rooms. You both of you be present. It should be in the presence of the lawyers.
My lord, kindly records my submission, my lord, because otherwise we are, my lord, facing some embarrassment.
Because you see, your report should be specific. You see,
I am out of money from 2017. It's 2025. I got a decree of eviction, not a single paisa paid.
now, actually now the court is going by your report.
My lord. Office room, my lord. Then there is office room, my
Which one?
lord. Second photo, my lord. Page, my lord. And you see, my lord, fast.
Second page.
Yes, my lord.
Second page.
That is fine. My lord, there is no doctor in the.
No, doctors require a chamber. Okay, without their chamber, doctor cannot run. Now the question is, according to you, 2 doctors are there. According to the judgment data, only 2 doctors are there. But according to you,
When I visited the premises, my lord.
till today, this as per the submission of the judgment data, there are 2 doctors. So 2 doctors at best can require 2 rooms. But as per your report, they are using all the 5 rooms.
Yes, my lord, they're using all the 5 rooms as office, and my lord, the photographs, my lord can see, my lord.
My lord, kindly records my submission that I am seeking, my lord, an order of police help today from the executing court, so that, my lord, through the receiver, I can get possession of all the 8 rooms. There is neither any law being cited to suggest that 3 rooms cannot be, my lord, vacated till such time a permission is obtained. Neither, my lord, they have challenged the decree. A judgment debtor will run his business from my property despite not paying me from 2017. My lord, this is, my lord, a situation, my lord, which the landlord never perceived possibly when he had let out the property. And after getting a decree of eviction, my lord, he has to wait so that the doctors continue to run the business. The judgment debtor continues to run the business.
Cannot be dealt on the same footing. All cases are to be.
My lord, I am not at his
Now-
mercy,
now
my
question-
lord. I am not
now
at his
question is
mercy.
when you are ready and willing to hand over the vacant position. For example, you leave aside these rooms, this instruments. So instruments are lying in 3 rooms. So for example, 5 rooms are there. How long the doctors will take to vacate these rooms? Very well.
My lord, Supreme Court is saying time and again 6 months is the time for execution.
No, very well. Suppose the rooms.
Get that,
Hey, judgment देखिए ना, राहुल is sir, judgment आज
But resources.
Rahul is sir, बार पहुंचा
There
जल्दी.
may not be a. But this is not a vacant
Rahul
property.
is sir.
The question is, that is why the question. 2 rooms are there. 2 rooms are run by the doctor, but total there are 8 rooms. So
The 8 rooms, my lord, 3 rooms are it- are there, my lord.
yes,
5 rooms, my lord. At that point of time when I visited, my lord.
2 rooms are
doctors are
2
visiting
rooms
me.
are doctor's chamber. 3 rooms
Doctors visit, my lord. At
in
that
their
point
own
of-
chamber. So 3 rooms medical instruments.
Yes, my
That
lord.
is 5.
Yes, my lord.
The rest 3 rooms only chairs and tables.
Chairs and tables and patient beds are there.
Because last time, my lord, a contrary submission was made. Lord, your lordships, my lord, indicated that all the 5 rooms are vacant. Today, the special officer is stating that.
Right, iPad ने जोसेफ को देखो. My lord, I want to rely only on one judgment, my lord. Why am I insisting for an order? I want to rely on one judgment. Kindly takes note of this, and whatever order Lordship feels, Lordship passes.
Yes.
My lord, 2021, I'll give a copy, my lord. iPad is there. iPad turn. My lord, kindly takes note of the citation. I'll give a printout. 2021 6 SCC 418.
No, give the copy.
My lord, I'll give a copy. My lord, this is, my lord, a recent, my lord, judgment of the, my lord, Supreme Court, where, my lord, the Supreme Court has said or set certain guidelines how the executing court, my lord, should function, and within what time, my lord, the executing court should, my lord, dispose of an execution proceeding. My lord, I'll give a, my lord, copy for your lordship, and also give a printout. For the time being, kindly looks at it from the iPad, my lord. My junior will hand up. Did it? My lord, the operative part of this judgment, this was in connection with an execution proceeding. Lordship will find that from the very first, my lord, paragraphs of the, my lord, judgment. If Lordship comes to, my lord, just after, my lord, the names, first para, leave granted. At a printout, anana. If you at a printout, anana. My lord has got that first para.
Yes.
Yes, my lord. Leave granted. Present appeals arise out of the common judgment and order dated 16 January 2020 of the Karnataka High Court, which dismissed several writ petitions. Course of litigation highlights the malaise of constant abuse of procedural provisions, which defeats justice. Frivolous attempts by unsuccessful litigants to putting up spurious objections and setting up third parties to object, delay, and obstruct execution of a decree. I will not trouble with the facts of this case. Straight away comes to, my lord, if Lordship scrolls down from paragraph 42 onwards, 41 onwards. Because this is, my lord, the guideline which has been framed by the, my lord, Honorable Supreme Court for executing courts, and I leave it to your Lordship thereafter, my lord. 41. Having regard to the above background, wherein there is urgent need to reduce delays.
Page 42.
Para 41, my lord, I'm sorry.
Para 41.
My lord has got that?
Yes.
Yes, my lord. Having regard to the above background, wherein there is urgent need to reduce delays in the execution proceedings, we deem it appropriate to issue few directions to do complete justice. These directions are in exercise of our jurisdiction under Article 142, read with Article 141 and Article 144 of the Constitution of India in larger public interest to subserve the process of justice so as to bring to an end the unnecessary ordeal of litigation faced by parties awaiting fruits of decree, and in larger perspective affecting the faith of the litigants in the process of law. All courts dealing with suits and execution proceedings shall mandatorily follow, kindly marks the expression, the below mentioned directions. In suits relating to delivery of possession, the court must examine the parties to the suit under Order 10 in relation to third party interest and further exercise power under Order 11, Rule 14, asking parties to disclose and produce documents. My lord, these are, my lord, the directions which are given. My lord, kindly calms down. (42.12). I will not trouble with the other subparas. 42.12, which is in respect of execution proceeding. 12.
42.12.
It starts with, my lord, the executing court. The executing court must dispose of, kindly marks this expression, of the execution proceeding within 6 months from the date of filing, which may be extended only by recording reasons in writing for such delay. The executing court may, on satisfaction of the fact that it is not possible to execute the decree without police assistance, direct police station concerned, to provide police assistance to such officials who are working towards execution of the decree. My lord, such officer is Lordship's officer, the receiver. Further, in case an offence against the public servant while discharging his duties is brought in the knowledge of the court, same must be dealt with stringently in accordance with law. Judicial academies must prepare manuals and ensure continuous training through appropriate mediums to the court personnel staff executing warrants, carrying out attachment and sale, and any other official duties for executing orders issued by the executing courts. It a follow-up recent actor. We further direct all high courts to reconsider and update all rules relating to execution of decrees made under exercise of its powers under Article 227 of the Constitution and Section 122 CPC within 1 year of the date of this order. The High Court must ensure that the rules are in consonance with CPC and above directions with an endeavor to expedite the process of execution with the use of information technology tools. Until such time these rules are brought into existence, the above directions shall remain enforceable. I am only inviting your lordship today to enforce, my lord, these directions of the Supreme Court and pass orders, my lord, in the execution, because there is nothing to suggest that either any permission is required from the government to remove, my lord, the machineries from the diagnostic center, or, my lord, they have preferred an appeal and got an order of stay. My lord, if this is the position, under what circumstances can my learned friend's client continue to, my lord, operate their business from this property? I, my lord, pray for orders in terms of prayer B of the tabular statement, which is, my lord, police help in view of the, my lord, Supreme Court directions. I leave it to my lord after this. I'll give it to your lordship. কত বলছিস? This is para 6. Print out until this.
What prompted this honorable pass this direction? Petition second proposition. But the practical difficulty has to be not seen in our I cannot just dismantle everything and hand over the possession. There are difficulties for which I have taken active steps.
Yes, record an order.
My lord, this is the book, my lord, just for convenience.
Also sees the letter which I have.
So your predicament is you have taken necessary steps, but you are not getting the permission. That's
Yes,
the only.
right.
Yes. But you are ready and willing to vacate.
Yes.
That will be recorded.
Very grateful.
Learned advocate for the Mr. Dotto, learned advocate for the
Thank you.
degree holder petitioner, advocate for the adjudicator, and learned special officer are present. Learned receiver are present. Has filed court drafts of order dated 10th June 2065. It is observed by the, it is stated by the learned receiver that the receiver came down to the ground floor of the suit premises to see whether the 5 rooms are vacated or not. Stop. But while visiting the ground floor, it appeared that the 5 rooms are still occupied with tables, chairs, patient beds, air conditioners, water dressing, fans, and lights. Stop. We also observed that 2 doctors are running their chambers in those 5 rooms, and patients are still visiting the doctors. Stop. It is also stated that in one of the 5 rooms, there is an USG machine which is still in running condition as stated by the judgment dated, and other 3 rooms are occupied by instruments for medical and pathological tests. Learned advocate for the decree holder submits that he is unable to get possession of the suit premises in spite of obtaining a decree. Learned advocate further prays for police help and relies upon a judgment of the Honorable Apex Court passed in Rahul S. Shah versus Jinendra Kumar Gandhi and others, reported in 2021, 6 SCC, page 418. Learned advocate for the judgment data submits that his client is always ready and willing to hand over vacant possession, and there is no requirement of any police help, but only predicament of its client is that necessary application for permission is made before the government authorities. Yes, which is the page?
My lord, page 6 of that affidavit.
Oh, no, no. Which page you have made that application? Let me see.
To the last date.
Last date.
My lord, 9 June 2025 affidavit of Mr. Kalyan Kumar Ghosh at page 6 thereof.
We have sent another letter.
Okay, okay, just a minute.
That letter does not show any permission was sought for.
Learned advocate for the judgment data refers to Annexure A, page 6 of the affidavit affirmed by one Kalyan Kumar Ghosh, annexing the copy of the letter addressed to the Additional Director of Health Services, Health and Family Welfare, Government of West Bengal, Shastro Bhavan, Sector 5, Salt Lake, Calcutta, 7,91,000. Stop. Learned advocate further submits that his client has also sent a reminder letter to the Additional Director. Yes, when was the reminder sent?
Copy letter. এটা তুমি যেতে পারো।
Refers to the order dated 18 June 2025. In the facts and circumstances, this court is of the view that the receiver should visit once more to the premises and record specifically about the number of rooms occupied, used by 2 doctors, number of rooms in which equipments are kept, and the rest of the rooms and the articles stored therein. Stop. Making further inquiry upon notice to the learned advocates of both the parties and the parties themselves, the learned special officer shall specifically submit the report.
Receiver, my lord.
The learned receiver shall specifically submit the report on or before 18/7/2025. Let this matter appear on 20/7/2025. Stop. As the presentation is made to the government authorities and permission not yet obtained, this court is of the view that a copy of the execution application, a copy of the affidavit of Kalyan Kumar Ghosh and a copy of the receiver's report be served upon the learned government pleader, State of West Bengal. Learned government pleader is requested to appear in this matter to assist this court upon obtaining instructions from the Additional Director of Health Services, CE, Health and Family Welfare, Government of West Bengal, Shastro Bhavan, Sector 5, Salt Lake, Kolkata, 7,81,000, with regard to Annexure A of the affidavit submitted by the respondent, and further instruction as to whether a specific permission is required in this regard. Let this matter appear on the date fixed 22/7/2025.
Kolkata 89 lordship said it should be 91.
Yes, 91.
91.
Kolkata
I
91 লেখা হচ্ছে তো।
90.
So serve a copy and the report.
Let me some remuneration be provided to
Yes,
the
yes, yes.
receiver, man.
Learned receiver is further entitled to a remuneration of 200 GMs. Okay, 300 GMs.
Is your lordship, my lord, this is my
I
application
appear for the respondent.
suit for eviction.
I, my lord, take the point.
Okay, is your application.
Yes, mine, my lord, directions for affidavit were given in December last year. Then in June, two affidavits have been filed, my lord. There's no dealing on merits. There are two technical objections which
I've
have been
taken
taken.
the point, my lord, with regard to locus of this particular
I filed a
petitioner,
reply, my lord.
with regard to the maintainability of the application itself. And I've, my lord, reserve my rights to only deal with the merits once, my lord, this is decided. My
Whether
lord,
any
since
such
I've
right
taken
can
the
be
point
resolved or
of
not, your lordship will
maintainability,
decide.
my lord, I believe, address first. If your lordship allows, my lord, then I'll show, my lord.
Applicant intervener.
No, he is the applicant. He is the intervener. He is not the applicant. I am the petitioner, my lord. There's no applicant here. He is the intervener.
I am not an intervener. I have
The
no
notice-
application.
He is not an intervener.
You are a
Notice
party.
I am a party. I am in possession, the tenant in respect of the property.
he is not the party, my lord. He is.
My
I
lord,
have
first
given
of
him
all,
notice
that
to
is on
serve.
merits, my lord. Let me first show.
Question is, who is for the plaintiff and who is for the defendant?
He is
The
intending
plaintiff.
to show that he is for the
Who is for the
plaintiff.
defendant?
My lord, the
Well, I am for
can
the
we see the
defendant.
application?
Okay, he is
Kindly
not
see the.
defendant.
Yes.
My lord, he is not the defendant.
My
Kindly
lord,
see the
first of
prayers
all,
in the
my lord,
application.
my lord,
Kindly
may
see
I
the
just
prayers in the
indicate,
application
my lord,
once.
may I just indicate first, I have taken the point with regard to his locus to file this petition before my lord. So first lordship sees whether, my lord, that these are all on merits. Lordship need not go into the merits. Whether I am a tenant, whether I should be evicted or not.
Is your application.
Yes,
GA
so
is
I am
fine. Kindly see
challenging
the
that
prayers
on
in
the
the GA.
ground of maintainability
Kindly
with
see the
his
prayers in the
locus.
GA, please, please, my lord. Kindly see the prayers in the GA once.
Wonderful. Volume two.
There will be a separate master summons, my lord. Master summons taken, Judge. Master summons taken on Jawaharlal Acharya. My lord, kindly see the cause title once, please, my lord. Ramendra Saha and Sons. Ramendra Saha and Sons, a firm having its principal place of business at so-and-so Portuguese Church Street. Now, my lord, kindly see the prayers. Delay, if any, in making the present application be condoned. Abatement.
The report was submitted.
This is with regard to, my lord, the report. The suit was dismissed for default, not restored. There is no suit at all. An application filed in a dismissed suit.
A certain deposition.
Yes, yes. Suit. I am not aware of the report, my lord. The
Question is, if the suit was dismissed, it was within your knowledge. Where is the order of restoration of the suit?
my lord, the suit was never dismissed.
I'll show it is dismissed.
Please show,
Let
please
him
show
show.
I'll
that-
show, my lord, it is dismissed. First of all, he has got no locus. And thirdly, my lord,
show that the suit is dismissed.
I'll show
So, yes, the suit is restored. Where is that order?
there is no order for restoration.
No, dismissal order. Where is
Yes,
that order?
kindly sees my opposition. Takes my affidavit in opposition, my lord. I have enclosed it. कॉपी कर लो देगा। हाँ? देता हूँ कॉपी के लिए। ठीक है। हाँ? ऐसा तो होता है।
6/12/1995.
Yes, my lord. Kindly, my lord, gives me one moment. My lord, kindly takes my
Yes, page 6.
rejoinder
No, no,
of
I am considering page 6 of your affidavit in opposition.
no, kindly takes the rejoinder. I have enclosed the order even of this court.
Yes, let me see.
Kindly takes the rejoinder affirmed on 9th of June 2025 and kindly comes to my lord Kindly comes to page 5. This is an document of this honorable court.
Page 5.
Yes, kindly seize, my lord. Typed copy is on the next page. Page 6. Nature of disposal. It's written dismissed.
Yes.
My lord, kindly seize. Nature of disposal dismissed. The suit is dismissed. Where is the order for restoration?
Dismissed, yes.
Then, my lord, I will show something more startling. Kindly come to page 7. This is an order which shows that this is a company. Now, my lord, Rajputana Trading Company. There is a liquidator who is there in this, my lord, appointed with regard to this company. Who is he to file this application before, my lord?
We see first of all whether the suit is, yes.
My lord,
you
this,
got this point, Mr. Thakkar, that
Yes,
the suit
please.
was dismissed.
Yes, my lord.
and this also there is a liquidator.
Now, my lord, your lordship sees what my learned friend is showing your lordship. He's showing from his rejoinder, page 6,
Yes.
rejoinder. Dhillon Kumar Saha's rejoinder.
Opposition is also there.
That the order I have also enclosed, my lord.
My lord, kindly
And
see-
my lord, the
let us
report
understand
will
what-
speak
my
for
lord, this
itself.
is just to delay the hearing.
No, there is no delay, my lord. There is no
Kindly, sir.
locus. No
Yes, yes.
locus for him to file the application.
Let us.
Has to be satisfied whether there was dismissal or not,
Yes.
whether there is restoration.
Second, my lord, secondly, kindly seize the order of Justice Kapoor. There is a liquidator. Kindly seize the rejoinder, page 7. An adjournment is, my lord, this is a very recent order, 20th November 2023. An adjournment is sought for on behalf of the official liquidator to take instructions and formal application for appropriate reliefs if necessary. It is a matter concerned that this matter has been pending for approximately 50 years. In such circumstances, let the matter appear in the monthly list. In the meantime, the official liquidator is directed to take necessary steps in accordance with law. Next page. None appears on behalf of the parties, nor an adjournment sought for. 18th of November 2023. Now, my lord, kindly comes to the latest order of 31st of July 2023. Official liquidator is represented. The department is directed to produce the records of this proceeding on the returnable date. The official liquidator seeks an accommodation to ascertain the exact position of the liquidation proceeding. Kindly mark it. In such circumstances, let this matter appear on 1st of September 2023. In the meantime, official liquidator is directed to file a status report as to the present position of liquidation proceeding and whether any purpose would be served keeping this proceeding pending. So, my lord, a coordinate bench taking up the company matter, there is an official liquidator appointed. How can some stranger come and file a execution proceeding before my lord?
Yes, so. you
So,
have
my lord,
to
these
clarify
are-
two things. One is
Yes.
that
Well-
the suit was dismissed for default and that it is restored. So regarding dismissal, your learned friend has filed that order. So where is that order? First of all, that the suit is restored.
Grateful, man. I understand that these are his preliminary objections. He has nothing further to submit on this.
I have.
Well, let him exhaust himself.
No. Yes, the suit is restored.
Very well.
Court is
My lord-
powerless, no scope.
Very well. Now, my lord, let us deal with, my lord, the company court orders first. Your lordship has seen 3 orders. Three.
I am concerned with this.
Suit. Very well, very well. Yes. Now, my lord, kindly see page 6. Your lordship has, my lord, of his
Yes,
rejoinder to the affidavit in reply filed by the plaintiff. What my learned friend showed your lordship, my lord.
yes.
Date of decision 31st December 1969. Case status, case disposed. Nature of disposal dismissed. Now, your lordship kindly sees his affidavit in opposition of 16 December. My learned friend has to make up his mind when the suit was dismissed.
It was dismissed
Now,
perhaps
kindly-
twice. The department is showing it.
Why has my learned friend then troubling your lordship with a 69 dismissal? A suit which is dismissed in 69 cannot be dismissed in 95. Let
There
him
is an
make up
order
his
of the
mind.
there is an order of court.
Please,
Kindly
Mr.
see
Banerjee,
page 6.
I did not
I have
disturb
not
you, sir.
finished.
Yes.
I am not
Then you please
finished.
finish.
Yes,
Then
I'll
you please
finish it.
Please finish. Please finish.
I'll finish it.
Yes, finish.
Now the question is, you see, Mr.
My lord.
Thakkar, page 6 is the order of dismissal, okay? Page 6 of the affidavit in opposition.
Yes. So now, my lord, let us then, if page 6 order of dismissal, your lordship sees 6 December 1995.
Yes.
Yes. So, my lord, then this order which Mr. Banerjee showed your lordship, my lord, page 6 of his rejoinder, that should be ignored. There
What?
cannot be the same suit which is dismissed once, cannot be dismissed a second
Document
time.
of the Honorable High Court of Calcutta, it should be ignored. What submissions are coming from the bar?
Because you see.
Have I created that document?
Considering the last order, okay, 6/12/2025, because this order is there.
6, 12, 20,
95.
6, 12, 20. So, my lord, I am not, then your lordship will not be troubled by this.
No, I
Because-
will.
No, I am concerned with this 6/12/1995.
How is
6/12/1995?
You are accepting this order?
No, my lord.
This 6/12/1995, the no order was passed.
No.
How is that possible?
It is
Is
possible.
an honorable judge, I think, recorded Ajit Kumar Sengupta. Was he not an honorable judge of this honorable court?
Probably no. 6/12/1995.
No.
Yes,
in
kindly
19
seeks.
in
Before Honorable Justice Ajit Kumar Sengupta, 6/12/1995.
Now, my lord, the Allahabad High Court says,
Suit
or
is
transferred-
dismissed for non-prosecution.
my lord,
No order as to cost.
so, my lord, he was not a judge of the Honorable High Court.
So I am not concerned. This is an order of this honorable court.
That must
There
be
is
Because
no
let
order.
there be a report.
Either certified.
Let there be a report. Because, my lord, I have enclosed all original copies of the orders of the court.
I
Nothing
don't
is
know where
manufactured.
I don't know.
Now,
This
my
is
lord,
not a
kindly-
certified copy.
My lord, I am not even interested. My lord, kindly sees the
This is
report.
fraud upon court.
Very well. If it is fraud upon court, lordship calls for the
Yes,
report.
call
I
for the
want
record.
to see.
Your
I
lordship-
want to see it.
You take it from me 6/12/2.
I am not concerned. This is an order of the court which is annexed. I want a report. He says so much na fraud upon court. Kindly let there be a report, my lord. I want to see. Kindly let there be a report. I want to see who is committing the fraud.
For the plaintiff and
मोबाइल दिखाई ना कि he was not the judge.
अरे जज साहब को पता है क्या करेंगे मोबाइल दिखाए
defendant are present. Are learned advocates.
रोजगार कागज बना
The first objection taken by the learned advocate for the defendant is that this suit was dismissed by this court on 6/12/1995.
And also, my lord, will kindly
Copy of the order, copy
the
of the order
rejoinder
ये देखिए चालान
marked Annexure A to the
affidavit in opposition.
in opposition filed by the defendant.
Yes, my lord.
It's advocate or the plaintiff submits that no such order was passed on 6/12/1995. Stop. It is also submitted by relying upon documents. Yes, which document?
My lord, this is in the rejoinder. This is the original downloaded copy from this Honorable High Court at Calcutta, my lord.
करने दीजिए
This is kindly sees, my lord. Page 6, rejoinder. And the orders of Honorable, my lord, Justice Ravi Kapoor. না না এটা তো ডাউনলোডেড কপি তারপরে অর্ডার গুলো লাগানো আছে
Not going through that order because that is company business.
yes so that my lord
No, no,
liquidator is there
I shall consider
very well
only this
very well very well that
Order.
will be my second submission
order. Relies upon the document.
downloaded my lord
Is downloaded copy wherein it is shown that date of decision 31st December 1969 and the nature of disposal is dismissed. Stop. The facts and circumstances.
My lord, may I just establish one more fact? Now, my lord, in the suit, which my learned friend says dismissed in 1969, then he says dismissed in
I
1995.
am not saying records are saying
Records are saying very well. Records are saying. Records will also show that in this very same suit, my learned friend's client has deposited occupation charges till 2023. So kindly call for a report for that. The production I've asked for, your lordship will kindly see the production which has been sought for.
absolutely my
Till
lord.
2023, my learned friend's client himself has paid.
Character
And before that,
proceeding is not with me
no, please do not interrupt, Mr. Banerjee.
if something
This is what you've been
court is
taught
being
in your.
misleading.
No, I am not
I can't-
misleading
I can't
anything.
help
Your
it.
lordship will see, kindly call for a report
yes
for
yes
this
kindly
also.
call for it.
এটা আরেকবার পড়ুন। So submitted by learned advocate for the defendant.
of the court website. My lord, only will write downloaded copy from the official website of the Honorable High Court at Calcutta.
Official website.
Yes, ma'am.
as it appears from order dated 6/12/1995 that the name of the judge recorded in the said order was not a judge of this, was no more a judge of this court. A report is required as to the genuineness of the order relied upon by the defendant, marked in Annexure A, the affidavit. Stop. As a report is submitted by the department that that copies of available documents, as most of the old challans, lodgement forms, letters are not traceable, and some certified copies of the available documents are submitted. Let this same be taken up for consideration on the next date fix. Let a report be submitted on or before 16
You know, my lord, next chamber day, my lord, your lordship keeps it, my lord.
next week. Actually, you see, it is not.
Next week is little difficult for me
difficult
also.
to do it within
Kindly,
short
it
period.
makes it week.
My lord, how is Mr. Banerjee's difficult? It was the department to be difficult.
No, the matter is there. I have to appear.
Before
He doesn't want to debrief me. I hope.
11/7/2025.
11/7.
Yes.
Great.
Let this matter appear on
Lordship will also kindly consider calling from the department.
15/7.
Yes.
2025.
Also, a department report, since your lordship is calling for the reports, let all the reports come once, my lord. We have got a report from we made a requisition to the department. Department has certified of payment of occupation charges till 2023. Kindly also.
You can take an inspection of
Yes,
this.
kindly, my lord, we'll give that liberty also to
Yes,
the
what
advocate.
is
on-
the-
Let also, my lord, call for a report from this, my lord, as to
Advocate
how
on
much
record.
has been.
Another thing, yes, learned advocates are permitted to take inspection of the report which is submitted today, as well as learned advocates are requested to submit a list of dates along with the relevant documents on the next
Grateful,
date fix.
grateful.
Give a list of dates and relevant documents.
Yes,
Very
yes.
As well as take
Very
inspection of this report,
Very well.
and with regard to the genuineness
My
of
lord,
the
there is
order,
one report or two reports, my lord.
this is with regard to. Yes, regarding forwarding letter, lodgement form, supporting document, challan.
So there is no report with regard to orders and my lord dismissal, therefore.
That's why.
Yes, grateful, my lord. This was required. Oh, it character report আছে।
ये है ये है ये रिपोर्ट है ये रिपोर्ट है लॉजमेंट फॉर्म चालान्स
पुलिस में suppressing the death of the tenant. उसमें रिपोर्ट दिखाया 69 का ये 69 की ऑब्वियस एंट्री था इसलिए रजिस्टर
सेकंड
रिवोक हुआ
कॉपी है
हाँ रिवोक किया ये 30 में
रिप्लाई का कॉपी दिए
हाँ वो फाइल की होगी ना मेरे को एक तो यही उड़ जाएगा और 95 में जस्ट थाने में होगी फाइल
Could you see there it is stated that as per copy of the minutes of order dated 31/12/1985, passed by the Honorable Justice Ajit Kumar Sengupta.
Is dismissed.
Is nothing.
My lord, may I,
My lord, may I just ask
may I
this,
tell
my
your
lord,
lordship
pray
this,
for
my
this.
lord? Mr.
Lordship will also call for the minutes book. Minutes book and the orders also in the report. That will clear everything. Kindly call for the minutes book and the orders for restoration.
Minute book is already there, my lord. We had sought production. The minute
Very
book is
well,
lying
it is
very
there,
much,
Lordship
it's
will
there.
look into it.
Minutes book be also put up on the next day.
And on the restoration order. And the restoration order. Suit has to be restored. There has to be an order of some
First there has to
honorable
be a
court.
dismissal, then there has to be a
Yes, yes,
restoration.
yes.
My lord,
Dismissal order is there.
Let this come first.
Yes, my lord. Let us look into it. Grateful.
The list of dates also and
Very well.
We will, my lord. Grateful.
My lord, the document, this computer sheet which my learned friend showed your lordship, the department has already revoked. It satisfies your lordship. There's a
I
the
don't
revocation
know.
is there in the reply.
I
That
don't know,
for
my
the
lord,
same
how,
computer which my learned friend says the revocation
how
of
it
the
is
wrong
revoked.
entry
My lord,
which
how
the
is it
department
revoked?
made while uploading on the
I am
computer
little-
system
I
that
am
has
little
been revoked.
surprised how it is revoked.
Then there should be an inquiry
without
against
an
the
order of
department
court.
also.
Yes,
Then there
let
should
there
be an
be an
inquiry
inquiry.
against the department also.
mistake in giving some
Yes,
information.
but revocation has to come by an order of court.
No,
Given by the department.
correct.
Mistake. So how the
My lord, there
Why
should
will
be
the court
if there is a
inquire?
revocation, it should go to all the parties irrespective of that, and there has to be an order of court. Who is doing all these things? I am surprised.
if they
Let
Lord,
the
who
report
is
come.
depositing
Let the
rent
report come.
with the department of
I
the
have a-
honorable court
I
in the
have
name
a
of a
right.
dead man?
I have
That
a,
your lordship
I-
will call for a
my lord,
report.
that is on
Who is
merits. That is
yes,
on
he will
merits.
not answer.
I will
He
not
deposits
answer to a
rent
stranger.
in the name of
I
a
will
dead
not.
man.
Yes, I will not
Yes.
answer to a stranger.
There should be an
Who is
inquiry as to
My lord,
who is
any
the cash,
person,
cash department
any
officer
person can
who has
come
accepted rent
and will
from
file a
a
petition.
dead man.
My lord, that is on merits.
Yes.
Yes, that is on merits.
Well,
Merits
ma-
lordship cannot get into now because lordship doesn't have jurisdiction.
Yes, your
Great.
lordship will be told your
So
lordship
what?
cannot do
Yes,
anything.
yes. What?
Your
Yes.
lordship will be
Let us
told your
look into
lordship
the
cannot
law.
do anything.
Let us not
When
go
he
into
goes
the
and
yes, yes
fabricates a
part.
rubber stamp of a
But
dead
let-
man.
Yes, cannot. No stranger can file a petition. I'll show it. Grateful. my lord.
ओरिजिनल चिट्ठी
तो अभी रहने दीजिए ना, नेक्स्ट डे
ना ना चिट्ठी आपको क्या फिर मेरे पास देखी कॉपी
आपको दे दिया ना वापस। इधर
petition. I'm the petitioner in the matter.
हैंडओवर किया गया
কেটিটা চলে গেল আমার দোষ মানে this the GA2 is my petition, my lord. অনলাইন আছে ও অনলাইন আছে ও দেখতে পাচ্ছি না but it's for revocation of the grant.
Your Lordship, I'm for the respondent, Your Lordship. I'm so sorry to interrupt. Your Lordship, I need to seek time, Your Lordship. The issue is this is a changed brief. And while I had been briefed last week, since then we've discovered that we haven't been given all the documents and all the pleadings because the client doesn't have them, Your Lordship.
Over, the same thing happened on the last occasion on 17th of June. Time was sought for. My application is pending for last 1 year. There's a report from the question department of the government of West Bengal specifically stating my signature has been forged.
Can you justify on the next day?
Yes. Now he keeps on and asks for an adjournment, and he knows that on 17th of June a similar adjournment was taken.
Anyway, come on the next day and try to appear physically. Okay.
I apologize, Your Lordship, for appearing virtually. I'm very grateful, Your Lordship.
We wait for here and just come in and say I've received the brief last week.
And I apologize, sir.
Welcome.
The matter stands adjourned till 15/7/2025. No further time will be granted.
Grateful, Your Lordship.
Lordship will kindly, because Lordship, this is the problem.
No, you see,
They have
please
taken the revocation. My signatures are forged. The department has said it's a forged signature. After this action of taking time has started.
15/6
And now they're dealing with the properties. There's the only thing after the report came from the department, repeated adjournments are being taken.
You see, on the next day, you see, if they pray for adjournment, you can pray for some interim relief on the next day. They'll pass some interim.
Only the relief are asking for revocation of the grant. I can't ask for any further relief today, man. It's only for the revocation of the grant.
Relief you have sought for?
No, it's not that. There's only the revocation of the grant and liberty filed affidavit in
Just
support
wait.
of caveat.
But it a last chance on 15th.
I'm grateful, Your Lordship. I'm apologetic, but I'm grateful.
Made, please, Your Lordship. I'm appearing on behalf of the decree holder.
Lordship, I appear on behalf of the judgment debtor.
For
And
an
Millard,
in respect of the immovable property. But there is a new application which is on board. Now, my lord, copy of the application has been given to the judgment debtor, but of the application has not been provided to me.
Are you a necessary party?
Not at all.
Yes, but the reason I say this, on last day, Mr. Mukhopadhyay, who was appearing for the judgment debtor, but I saw from his brief that certain prayers have been prayed for, that a receiver be appointed to take possession of the immovable property.
Millard, Your Lordship will kindly, Millard, to cut the matter short, Millard. Your Lordship will kindly see, Millard, the order passed on 12th of June. They had to file, Millard. Yes, Millard. We are expecting an affidavit in opposition from the judgment debtor, which they ought to have filed on 20th of June 2020.
I am for the judgment debtor. Lordship, the affidavit is ready, Your Lordship. Just it is pending. We'll take the leave of Your Lordship.
No,
We'll file
kindly,
it
my lord.
within the department in the course of the day. We are handing over a copy to them.
This cannot go on, sir. Millard, kindly, Millard, sees Your Lordship last 3 orders. How they have procrastinated and prolonged the matter. This only is in respect of mean profits.
Lordship, I am handing over Your Lordship the copy that has been affirmed by them. It is just pending, Your Lordship. It is just
Are you
pending for
My learned
affirmation.
friend is filing, then
I'll just file it
can-
within the course of the day, Your
Go
Lordship.
ahead,
I'll just
can-
take leave of Your Lordships to file it within the course of the day, and a copy of the same is handed over to the respondent, to the
Lordship, Millard,
award
kindly
holder.
come to the order of 22nd May 2025 or 13th May 2025. Millard, may I demonstrate this to Your Lordship? And I can assure Your Lordship, Millard, that with respect to the intervener, Mr. Basu's client, I'm not asking for any money on mean profits from his client.
No, but mean profit is a separate issue that is between the decree holder and judgment debtor.
Have you received the possession?
Not at all. And that is under contest with an application filed by Mr. Basu's client,
How much?
which I am not.
How much? What is the area of the?
Millard, this is under, Millard, I am not ventilating my rights with respect
No,
to
if you have some
recovery.
you file your independent
It
application.
is already
He's already filed. 47 is there.
J1 of 2023 is my app.
One of 2023, have you filed affidavits?
Yes, it is complete.
Proceedings are complete.
It was already being heard. In the meantime, this application relates to mean profits. That is all. So Lordship kindly sees a Lordship's order of 13th May, and the situation will be clarified.
This GA1.
This is, Millard, GA5, which is presently before your Lordship. Only respect
You
to
have
mean
received
profit.
copy of the affidavit?
No, I am not going to, because your Lordship
I'll
will
just
see that they had to do it on 20th of May after final chance, final opportunity repeatedly given to them. That's why I invite your Lordship's kind attention to the order passed on 13th May.
Affidavit in opposition? No.
Lordship, the affidavit,
Millard, yes,
12
but
June,
before that,
Your Lordship, for filing
I
affidavit in
request your
opposition.
Lordship, please, one by one. I request your Lordship to kindly come to the order dated 13th May 2025. This is not supposed to be done. Eavesdropping has now gone to handing over of the petition to him. Millard, kindly similar, 13th May 2025. Learned advocate for the petitioner. Decree holder is present. Time is sought for on behalf of the judgment debtor. In the facts and circumstances of the case, the matter stands adjourned. Now, Lordship, kindly see the next order, 22nd May. So, first adjournment. Learned advocate for the decree holder and learned advocate for the judgment debtors are present. Learned advocate for the judgment debtor submits that they were confused with regard to application as because no number was given, and the learned advocate prays for time to take instruction. Then your Lordship further passed, the prayer for adjournment is opposed for the decree holder, although several opportunities were granted, kindly marks this, but no steps were taken by the learned advocate of the judgment debtor. However, learned advocate for the judgment debtor is requested to serve copy of necessary particulars and case number upon the learned advocate of the judgment debtor to take necessary instruction without any failure. And your Lordship fixes 10th June as the next date. Now, 22nd May was, Millard, very near to the vacation. Now, Millard, kindly see the order of 10th June 2025. No, Millard, 10th June is in between. That's why I'm suffering. That's why I'm making this submission. Now, learned advocate for the judgment debtor prays for an accommodation. So, again, an accommodation sought.
And then 12th June?
And then 12th June, for the first time, over a month, they come up with the prayer for an opposition. We do not stand in the way.
Well, 20th June.
And 20th June was the date for them to file it, not affirm. Affirmation obviously precedes filing. So, my lord, in this conspectus,
Reply, if any.
by 25th, even
25th.
that date is already gone. So, my lord, today in the conspectus of an execution
Not
proceeding,
yet affirmed.
it is not yet
Lordship,
affirmed.
it is affirmed. Your Lordship, I'll just give the
The
affirmed
lordship will
copy.
see the date.
Your Lordship, I'll just take the
Would have mentioned the matter, sought your lordship's leave, then affirmed.
When did you affirm the same?
Lordship, it was affirmed yesterday, and the reason being that the award letter was not, he was out of station and he was not present there. So that's the only reason we could not affirm it.
It ought to have been filed by 20th June.
I seek your Lordship's
Good order.
apology for filing it so late. Your Lordship, it's absolutely affirmed, and we'll file it within the course of the day, and the copy of the same,
It was affirmed yesterday, that is on
25th.
24th, 25th.
25th, Your Lordship. And we have affirmed it. We are handing over a copy of the same. The reply, if any, being if they want to give it, they might give it.
My lord, I am under strict instruction not to accept it, and I beseech your lordship not to, my lord. I beseech your lordship, my lord, to fix it.
far as the
Just a moment.
No, let
I'll
him
make-
submit, please.
Very
But so far as the present application that has been filed in 2025,
Yes.
I believe Mr. Banerjee is not asking for any prayer for possession. Because if he asks for any prayer for possession, then my application under Order 21, Rule 99 will be rendered infructuous.
Very well. Learned advocates for the judgment debtor, learned advocate for the degree holder, and learned advocate for the judgment debtor are present.
My lord, I was making one submission, lordship
Yes.
kindly permits me. My lord, in this conspectus of the orders passed by your lordship, repeated violation is manifest from the orders. They are not, my lord, diligent to come up and take permission from your lordship. Kindly, my lord, do not accept their affidavit and
Right.
fix the date.
It's for the judgment debtor is present. Learned advocate for the judgment debtor submits that the affidavit in opposition is ready, affirmed yesterday, and press file the same.
Within the course of it.
Such prayer is objected by learned advocate for the degree holder. Learned advocate for the degree holder submits upon referring to different orders that repeated adjournments were obtained, and although by order dated 12 June 2025, prayer for filing affidavit in opposition was allowed and liberty was granted, file affidavit in opposition by 20th June and reply if any by 25th June 2025, and the matter was required to be heard under the heading chamber application adjourned, but the same being not done, the hearing of the matter has to be adjourned, causing prejudice to the degree holder. Stop. In the facts and circumstances, this court is of the view that the affidavit in opposition should be accepted subject to the payment of costs by the judgment debtor to the degree holder. Thus, liberty is granted to file the affidavit in opposition subject to the payment of costs of 200 GMs on or before 30th June 2025. The reply, if any, be filed by how long? 30th June?
I had sought for 5 days. I still remain with the same submission, my lord.
Reply, if any, should be filed by 1st July 2025
My lord, 1st July is one day. 30th June, your lordship has given the
regarding payment of cost.
payment of costs.
But I'm granting him liberty to
By-
file the affidavit in opposition right today.
Yes.
But it will be accepted subject to the payment of cost by 30th of June.
I
So you are receiving the copy.
bow down.
Let the affidavit in reply be filed by 1/7/2025. Let this matter appear on 3/7/2025. As the application is filed.
GA5.
No, what is your
Mine is GA1 of 2023.
GA1 of 2023 is filed? Let it also appear on the said date.
Yes, ma'am. In the meantime,
Lord, may I make
the new application that has been taken up for hearing, wherein one of the judgment debtor is filing an affidavit,
Yes.
a copy of the application may be given to me
No, no, it's not relevant.
Because if he has prayed for possession, then I need to oppose the prayers.
Yes,
No, I have
yes.
not prayed for possession.
No,
You just follow. If you find anything prejudicial order, you come with the necessary application.
my
Right.
application is already there on board. If he wants possession,
Yes.
then my lord, my application will be rendered infructuous because under Order 21, Rule 99, if I am not bound by the
Each and every application can't be served upon you. You have filed your application, that would be taken care of.
But lordship,
Suppose
Yes.
the court passes any order of handing over the possession,
Yes.
okay, without hearing you, definitely a date will be fixed for you to make the submission. Each and every application can't be
but I
served.
only am my anxiety is only this, my lord, that my
See,
the
whenever
degree
you
holder.
see one application is there, suppose an order is required to be passed in this application regarding handing over possession, your application will be taken up for consideration. Yes. on the
Lordship.
file.
My lord, may I make one prayer? My lord, I appear for the judgment debtor. My lord, one humble prayer, my lord, if I may be permitted to make.
Yes.
My lord, only if the quantum of cost could, my lord, kindly consider, my lord. My lord, my client is an ordinary individual, 5 days delay only, my lord. Only a quantum of cost, some consideration.
200
Let him
GMT is not a-
vacate. Let him vacate and go if he's an ordinary person. Why is he clinging to
My,
my?
my client is not in possession. That's my specific case. He's not in possession. My lord, kindly consider, my lord, 5 days delay, my lord, kindly consider.
It's already
Kindly
decided.
consider.
It is already
Okay,
decided.
okay. Instead of cost,
My lord, it is already decided. I object to this, my lord. Already decided.
okay, you pay the
No, my lord, this is my prayer. It's between the court, my lord. My lord, I'm praying before my lord. Mr. Banerjee may have his say in the application.
150 GMs.
I'm deeply obliged.
Obliged, my lord.
James first. Okay.
My lord, am I audible?
With the power to appoint the Mutawalli. Now, my lord, we are seeking, we are the beneficiaries of the Waqf my lord properties. We are the members of my lord the Asna Ansari sect of the Muslim community, my lord, who are the beneficiaries, my lord, of the mosque, which is the only
means
Shia mosque.
You see, that means you are seeking them you are seeking to remove them
Yes.
on the grounds of some allegations.
Yes, correct.
They require to file an opposition.
Yes, yes, my lord. Only one submission, my lord. They have proposed to remove me also. I am the Mutawali. Now, my lord, the maintainability of the suit before this Honorable High Court, this issue was pending, subject to correction. Now, my lord, there are other connected application in connection to this suit. Now, my lord, I don't know, my lord, whether that issue has yet been resolved, that whether, my lord, this Honorable Court.
You
take another application, that was an issue in another suit, my lord. In this suit, there was no hearing.
No,
that
as
was
No, my lord, the entire issue, whether these suits are maintainable before this Honorable Court was, my lord, under consideration. Let my learned friend submit that that issue has been decided.
You are representing whom?
Then, my lord, we can proceed with the.
You are
I am representing the Mutawali.
Okay. So have you served
The Mutawali, my lord, who has been sought to be removed.
Yes, accepted.
And the Mutawali is present before your lordship also.
Mr. Ali is appearing for the Nazids.
He is appearing for the Nazis.
So you
appointed by this court.
Yes, you are seeking to remove them.
Yes.
No, my
So,
lord. What I
all.
see is direct the Nazis of Waqf estate named in paragraph such and such to show cause as to why they should not be removed and new Nazis be appointed. Yes.
Yes. So some allegation is there. They should be granted opportunity to file opposition.
Obviously, man.
Yes. Mr. Ahmed, learned advocate for the applicants, stroke petitioners, Mr. Ali, learned advocate for the Nazids, and learned advocate for the Matwali are present. As the applicants sought to obtain an order against the Matwalis and the Nazids.
One Matwali, my lord.
Yes, one Matwali and 3 Nazids. Lordship. They should be granted an opportunity to file affidavit in opposition. Let affidavit in opposition be filed by 15/7/2025. Reply, if any, by 22/7/2025. Let this matter appear on 24/7/2025.
When the parties are all appearing before lordship.
Grateful, my lord. My lord, I've given my name in the chat box, my lord.
Yes, yes, yes. It will be.
I'm praying for not today, my lord.
Item 13?
I'm praying for not today, my lord.
Okay, not today.
Lord, 13, my lord, I was praying, my lord. Lord, this is suit, my lord, of 1935. My lord.
You are for the state authority.
For the state, my lord, and my lord, the state has been made a defendant not in the suit and not an application, but the state, not for discharge of the receipt is pending, which was to be heard, my lord. In fact, that has to be heard first,
That
not
is
before.
GA 280.
Yes, but my GA is not GA 238, not may that also be listed next week, my lord. Both the matters may appear. Not the
Okay.
state's GA is GA 238 of 2022.
Copy served.
Yes, sir.
Yes. Learned advocate for the petitioner and learned advocate for the state are present. Let GA 238 of 2022 appear along with GA 280 of 2025 on.
I'll kindly make it not, give me little not more than Monday, not if it could be 1 or 2 days after.
Appear on Tuesday.
Very good. Tuesday.
1/7/2025.
Lordship. Grateful to Lordship.
Item number 14.
14, Lordship, I am for the applicant, Lordship. That is the matter, Lordship. We are the Sebaya, that is the Devattur property. In this regard, Lordship, already pleased to pass an order in GA 60. And same order may be passed. This is the, there is the scheme already considered, and this is the order already passed in it.
GA 61.
GA 60. Same order may be passed. This is my affidavit service already made.
Fight for any key. Yes, what is the notice of motion?
Yes, that is already filed. This is my affidavit service. Already filed.
You are representing?
No, I am representing other group of Sevites.
So you are for the Shevites.
Notice already.
Other groups means which defendant?
2A, 2-1.
Okay, this is by defendant number 1A and defendant number 1B. That is Devopriyo Sen and Devobroto Sen.
Yes,
And you are representing?
2A, 2-1.
2A.
Yes, my lord. 2A, 2-1. 2A1.
No, you are representing only 2A1.
2A, 2A1.
2 Prabir Kumar De.
Yes.
In this regard, Lordship, please to consider the previous order, that is
No,
in GA
2A,
60. None of the
2A
parties are.
and 2A1.
Yes, sir. None of the parties are appearing in this matter. Lordship, please to consider already, Lordship, please to pass an order on 19th of.
The scheme was there, my lord.
There is page 31.
Yes, record an order. Learned advocate for the petitioner, defendant number 1A and defendant number 1B, and learned advocate for the defendant number 2A and 2AI.
Yes,
are present. The petitioner in the instant case has prayed for grant of leave to enter into an agreement with the developer for development of the subject property being premises number 242/2 capital D, Acharya Prafullo Chandra Road and 113 capital A, Raja Dinendra Street, PS Bortola, Kolkata 7,06,000, measuring about 15 kathas, 5 chitaks, 17 square feet, as it is mentioned in the offer letter. It is contended by the petitioner that the civil suit being 1147 of 1947, which was decreed by final decree dated April 9, 1959, passed by His Lordship the Honorable Justice Prakash Chandra Mallik, as His Lordship the then was, framed a scheme together with the map and plan annexed thereto. Stop. It is further contended that the final decree by framing of a scheme was passed, declaring the Shebaiti rights of the duties in respect of the parties therein, as well as confirming the scheme framed, directing the parties to each on the condition of the scheme. The parties were also granted liberty to apply before the court from time to time when occasion arises. It is contended that Khagendranath Sen, by his last will and testament being 1039 of 1990 and probate granted by the Rani High Court by the High Court, Calcutta, bequeathed all his movable and immovable properties among the legal heirs comprising of his wife, 2 daughters, 2 sons. It is also contended that the property is situated at premises number 242 by 2D, Acharya Prafullo Chandra Road and 113A Raja Dinendra Street, PS Bortola, Kolkata 7,06,000. No, have you pleaded the necessity for selling the property? Yes. Which paragraph?
Please to consider the paragraph number, page number 15, paragraph number 5.
15 paragraph. No necessity of this sale, the legal necessity, which is usually the ground for granting permission. No, you have agreed, you have entered into an agreement. Yes. That is okay, but why? Where is the legal necessity? Yes, suppose it is not fetching income, it is difficult to maintain, there is urgency, without fund you cannot develop. Where are those, which paragraph you have stated that? Giving the particulars of the income and expenditure of this property. Anyway, if you want to file a supplementary affidavit.
Not necessary, Lord. We already agitated it.
Yes, where, which paragraph?
Finally, also consider page 19,
Yes.
Roman 12.
Yes. Roman?
12.
Yes. Okay. It is also contended that to redeem the property and to generate an income for the Devottar estate, the petitioners were trying to find out a prospective developer. And thus, one developer, namely Kavish Realtor Private Limited, approached the petitioners for developing both the said first property and second property on certain terms and conditions. Yes, upon hearing the learned advocates and considering the facts of the case, the petitioner has been able, this court is of the view that the petitioner has been able to make out a case for grant of permission to sell the subject property.
Page 25.
Thus, the prayer of the petitioners should be allowed. Let there be an order in terms of prayer A, B, C, and D of the notice of motion dated 22nd day of May 2025.
E is also required.
E is also necessary. Lord.
E is at present not necessary. You carry out this up to D.
E to invest the balance amount of the consideration money available out of the sale of disposal of the 40% build up.
For that, you see, some scheme has to be framed, some further directions are required. Okay. You just conduct the sale, submit a report of the sales. Thereafter, necessary orders can be passed.
He may be allowed, Lordship. The previous order already, Lordship, please to allow for the sale also.
No.
Lordship, please to consider the previous order. I have already handed over the order passed by your Lordship.
No, that is there, but
The kindly Lordship. There is the Devottar account also, Lordship. The auto that can be.
okay, E, prayer E of the notice of motion.
Grateful.
And E of the notice of motion.
Application dispose of it.
Yes.
Macho.
Because Yes, all the list. Fixed matter.
Item number 18.
I approve for the plaintiff
My lord,
respondents.
I am appearing for the defendant number 6, my lord. There are two petitions which has been filed, my lord. One is for recall, one is a demurrer application. My lord, it's essentially on the non-service of writ of summons for an extended period since 92 till date, wherein several amendments have taken place, but writ of summons was not served. My lord's pleasure on the last occasion was to hear Mr. Bose argue the petition, but I'm being led by Mr. Bose. Some personal difficulty, my lord. He's elsewhere, my lord. If my lord would kindly allow an accommodation today.
This was fixed, my lord.
My lord, I bow down to
So
that.
affidavits are complete.
My lord,
Affidavits are complete. They
Mr.
have
Bose had also argued substantially
for the
before my
previous court. They have argued
You are
could not complete.
My lord, for
you are for the plaintiff.
my lord, he's for the plaintiff. I am for the defendant number 6, whose application is before my lord.
Their demurrer application.
You are opposing their application.
Lordship.
GA 25, you are opposing their application.
My lord,
So both their
25, 26.
applications 25, 26, I'm opposing. One is for recall of orders and another is for demurrer, Lordship.
Demurrer
So
application.
affidavits are complete.
My lord,
Affidavits are complete, Lordship. They had argued extensively before the previous court. They could not complete, took adjournments after
My lord, there
adjournments.
was no. My lord,
have you
was
prepared
before
written
Lordship
notes of
now.
arguments?
my lord, no written notes of argument.
So
My lord, if it-
Lordship
if
has
pleasure-
asked them on the last occasion to
my lord, if
prepare
it- my
written
lord,
notes.
pleasure-
Prepare written notes of arguments as well as a list of dates on the next day.
Very well, my lord.
But, my lord, I'm strongly opposing, my lord, this prayer for
Learned
adjournment.
advocate for the defendant petitioners and learned advocate for the plaintiff opposite parties are present. On the ground of senior counsel, time is sought for by the applicant defendant. This prayer for adjournment is opposed by the plaintiff opposite party. Stop. However, in the interest of justice, one more opportunity is granted.
Let it be the last, my lord.
Granted, one more opportunity is granted to come ready on the next date fixed. Learned advocates are requested to come with written notes of arguments along with list of dates. Let this matter appear on 16/7/2025. এই দেখুন তো 16/7 মানে 3 PM কোনো ফিক্সড আছে কিনা 16/7 Okay, 16/7 at 2 PM.
Very well, my lord.
ফিক্সড করা আছে 17/7 দেখুন Okay, 17/7 at 2 PM.
Grateful.
Yes, but I'm fixing the matter.
My lord, grateful.
The next day, either the senior counsel or you must come.
My lord, we will, my lord.
Will it be
Grateful.
Lordship's pleasure to record this is a peremptory?
My lord has already recorded its time.
No, it's not.
Yes.
Grateful, my lord.
Anyway, let us see on the next day.
Grateful, grateful.
Because this has, we have been
My lord,
suffering with
my lord,
this
90
prayers for
to 2,
adjournment
they
for
have
quite
done
some
nothing.
time.
All this while, now all of a sudden urgency comes up.
Okay, but if the senior is not present, you have to come.
My
ready.
lord, we will, my lord, we will. Grateful, my lord, grateful.
Urgency আসবে না
Item number 15.
My lord, item number 15 and 16 are the identical matters. My lord, in this, by way of this application, I'm seeking a innocuous pair. I'm seeking a direction upon the special officer.
G18. G18.
Three.
G8 you are moving. You are appearing for?
Applicant.
Yes?
Applicant, my lord.
Applicant, that is intervener, or you are a party to the suit?
I was the intervener.
Let me see. G8.
Mr. Rajeshwar Singh, Kapileshwar Singh.
Who is opposing this application?
My lord, we have served notice.
Okay, none is appearing. Okay, let it be not today then.
My lord, can you give me a direction to serve our notice again? I can serve.
Let it be adjourned for the day on the next day if they don't appear.
My lord, my lord. Item number 8 and item number 15 and 16.
is item number 8. This is item 15.
15 and 16.
Okay, 15 and 16. Okay. I'm just simplicity making it not today. But you have served intimate the other side.
Yes. Yes.
17. Okay, not today. 20. Yes, you are appearing for
Different number 3 and 8, my lord.
GA application is whose application? GA 43.
Application.
GA 43.
No, I was in item 17, my lord. I'm sorry.
17.
Yes.
Yes, 17. You are for?
My lord,
Yes, both sides are here. 17.
my lord, there is no both. There is no other side. This was actually a very old suit, a partition suit of 1963.
Yes.
Final decree was passed. My lord, this application
You are
requires.
representing whom?
My lord, the applicant, my lord, the plaintiff number 4.
The present plaintiff number 4.
Yes.
Item 20.
No, this is 17.
Oh, 7. I'm sorry.
Because the display was showing.
Display, yeah. Display to 20 দেখাচ্ছে।
The only thing, my lord, the records, my lord, of this matter are required, which are untraceable. So if your lordship kindly directs, my lord, for the department to bring the records, my lord, before this honorable court, then it would be much easier.
You have prayed this thing. Condone the delay order passed by modifying, by recording deaths of plaintiff number 1 to 3. All these things.
Yes, those things are there, my lord, but the records are not available, my lord, of the suit before your lordship. So I was humbly praying, my lord, if that direction can be given to the department.
But for this purpose, you see, service is also necessary to be caused upon the defendant.
Because the plaintiff number, the plaintiffs were are all dead, and the defendant, my lord, he's also not there anymore.
Defendant is also dead.
Defendant is also dead.
Anyway, his heirs are required to be heard on.
There are no heirs, my lord, of either the plaintiffs. The plaintiff number 1 was my mother.
No. For the defendant, there are no heirs.
No heirs, my lord.
So it has to be represented by a special officer of this court.
Yes.
That has to be done. You have to take out an application for that. Anyway, I am letting the record to be directing the record.
Yes. And in the meantime, I'll take steps.
Somebody must be there to represent the defendant.
I bow down to your lordship.
Yes. Learned advocate for the plaintiff petitioners. Which plaintiff?
4, my lord.
Plaintiff number 4 petitioner is present. As the records of the suit is not before this court, let the records be produced on the next date fixed. Let this matter appear on.
Record produce করতে বলছে, he needs to take out an application.
22/7/2025. 21/7.
21.
In the meantime, you take steps. Otherwise, the entire thing will be meaningless. If there is no defendant.
Number 20. Around 20.
My lord, may I only, my lord, beseech your lordship to give a direction for paper publication in, my lord, in respect of the defendant only.
That will be considered. You, unless you file any application,
Make the application.
you have to give the name of the heirs, or you have to say that there are no heirs. Whatever it is, you have to come with a case. Okay.
My application, your lordship.
I am appearing on behalf of the defendant number 2.
I have a plaintiff, my lord. I am the special officer. Rudrara and Chaudhary Partition.
I wish to file an opposition to the instant application.
What is your application?
No, I would like to disclose some certain facts which are relevant for the adjudication. What my learned chief.
It's my application, your lordship.
I am
I will very abjectly oppose that. Your lordship, this is in somewhat of very quaint and grueling circumstances. The building in question, it is in dilapidated condition. It can come down any day. My limited prayer over here is to take out expenses from the account that has been maintained by the special officer for maintenance of the building. One document I will showcase to your lordship that would
proffer to your lordship the pragmatically necessitated conditions that are there as of today. Your lordship will just kindly take up page 34 of my application. There is one more aspect that I need to satisfy the conscience of your lordship.
Anyway, I am giving them a short direction.
No,
there's an issue of maintainability against the.
Maintainability, your lordship, I will satisfy.
So you are representing whom?
I am for the defendant number 2, your lordship. The funds which are lying with the special officer are of the estate. Lordship, our tenants welfare association has come up before your lordship in a partition suit seeking to take leave of the court and take out money from the funds of the estate and repair
You see, if the landlord refuses, you can cause repairs. Repairs cannot be prevented. If you cause the repairs and you recover it from the landlord.
Let them cause the repairs.
My lord,
That
may
is
I
the
submit
instance.
one thing, my lord? I am the special
Yes,
officer.
yes, yes, yes.
My lord, what happened? Number of times a chunk of this concrete has fallen on the road. My
Oh,
lord,
repair. Nobody, you see, there are decisions.
no.
Nobody
I
can
know.
be prevented
I
from
know.
causing the repairs.
My lord, the corporation on 1st of April, my lord, issued an 3rd of April. So I called upon in a meeting of 16th April where the plaintiff, the defendant number 3, defendant number 8, they were present. Defendant number 2 was not present, and the tenants association was present. My lord, there they have decided it has to be done to get rid of this thing. So where from the fund will come? Now it is up to your lordship where from the fund will come.
Definitely
Whatever
cannot be
lordship
out of the
directs-
estate of the
He was-
partition suit.
he
That
was
cannot
not
be.
appearing, not
I am
coming to
appearing
the-
here. I am.
You are a
my
tenant.
opposition.
You are
No,
a-
I am one of the landlords.
But he never.
I am the defendant number 2.
You
It
are,
doesn't matter.
okay, you are a owner, you are a tenant.
Yes.
I am for the tenant.
Tenants well wisher.
You are?
I am for the plaintiff.
I have no objection because
The plaintiff resides there.
I have instructions.
Citing that some of the co-owners as well as the tenants, most of them are residing
You are
there.
representing plaintiff number?
Only plaintiff.
You are representing?
Defendant number 2, your lordship.
I am defendant number
Yes.
3 and 8. I have not.
Your lordship will just allow me to showcase one document, then I will leave it to your lordship.
Your
Your
lordship,
lordship, with respect to the
I
issue
don't
of
think
maintainability.
This application cannot be entertained like this. Let me put in all the records, whatever is required.
Number of
The lordship then will take it up.
The dilapidated condition has come.
Oh,
to the
your
honorable
objection
court,
is
and
only
this-
with regard to fund.
If my learned friends wants to repair the premises at his own expense, he is free to do that.
Yes, yes.
It cannot be out of the fund of the
Well, they are what I am,
estate.
they are giving the maintenance also. That is why they said now it's up to your
It
lordship.
is not my learned friend's case that
Your lordship, he can move my application. Let him move my application. Your
Anyway.
lordship, as tenants,
My application, I have also filed an application. Your lordship also take up my application.
What is your, which application is yours?
your lordship, mine is
My application is
GA43.
Which one? GA? No, I am now taking GA 43.
43 of 2025 in connection with.
What is the, there is no other GA.
No,
Only
Not
G and G is coming.
Okay, next day it will be taken up.
Your lordship,
Yes.
just allow me this, your lordship. Your lordship, with respect to the issue of maintainability, that is something I need to satisfy your lordship's conscience about. Your lordship, these applications have come up before this also. Your lordship, this honorable court has entertained them. I'm not saying that, your lordship, that should be a ground on which I surpass the threshold today. But your lordship, these are certain grueling circumstances that is on the ground today. Your lordship, I will showcase 2 orders that have been passed by this honorable court, your lordship, wherein these aspects have been taken into consideration and repair works have been ordered to be carried out. Your lordship, even after that, repair works due to the lack of funds, your lordship, because we are paying maintenance charges every month, your lordship, 55,000 rupees.
No,
in
how much is the cost of repairs? Any cost of
Your
repair?
lordship, I-
Estimate.
I have asked them. Some official quotation has been given. Some has given 16, some 12, some 15. I'll call
16
lakhs, my lord. My lord, I will, the funds are there. My lord, I will call upon after this order, my lord, whatever lordship passes, I'll call upon a meeting and there they will
Question
be
is, you
decided.
see, landlord can carry out, it is the duty of the landlord as per the Premises Tenancy Act to carry out the essential repairs. Suppose landlord does not carry out, as because the suit is pending or whatever it is, the tenant can carry out the repair and recover it from the landlords in accordance with law. That is, that provision is there. So why in the partition suit the court will direct the landlords to spend the fund? No, special officer is representing the state. Why in partition suit this court will pass this type of directions?
Your Lordship, I understand that because Your Lordship, we are paying maintenance every month for maintenance.
That
of
will
the
be
building.
decided. Okay, you reserve this stand. Okay. Thereafter, if you want a recovery from these parties or from, you just make another application. But
That would just multiply the application, Your Lordship. Anyway, Your Lordship is so
because
burdened.
once there is an objection, okay, how in this
There are
partition,
This objection is
in this,
nothing but
you see, in this
nature.
partition
He has
suit,
not been appearing in the suit in neither of these applications. Suddenly, he
because
comes
in
up with
the
out of
in
some
partition suit, okay,
I got it.
these applications by the third party, okay, it can be entertained, but subject to the provisions of the statute. Under the provisions of the statute, you can carry out the repairs and recover it from the landlord. That is always there. But how can I direct, you see, in this partition suit, when there is an objection, to allow them to use their fund?
Your Lordship, because the plaintiff is not objecting. None of
All
these
are co-sharers. The
Lordship,
defendant is co-sharers.
I bow down to that, Your Lordship.
My lord, every time the party is not coming, my lord, especially different number 4 and different number 2. And my lord, he said, I'll object, I'll go to the court. Well, come before it. The meeting is here, everybody is here, your property, this is not my property. I am the just manager, I am special officer representing the court. Why you're not coming to me? Your lordship sees series after series minutes, my lord. He hasn't.
You're representing how many tenants?
Your Lordship, these happen
Six-
to be
43.
How many tenants are there?
May I say, the 83 rooms they are in Badawazar, 20 is under the custody of the co-sharers, 20, my lord, disputed tenants, and 43 tenants, they are, my lord, now.
They have come.
They have come.
and we are paying maintenance charges every
Every-
month.
I'm collecting rent, my clerk goes every time.
So not a matter of one tenant. So many tenants are there.
They have all accumulated.
At this stage, I cannot direct fund. That I can permit you to carry out the repairs at your own expense. That point will be kept open. You can take that remedy. Take that point.
Your Lordship, let that point be kept open. Your Lordship, at present, I am just seeking for help because I understand the embargo that Your Lordship is facing. Your Lordship, I am on a limited credit for a leave from Your Lordship to carry out the repair work.
Yes, take down.
And Your Lordship, the point be kept open for me to
Learned advocate for the applicants, tenants of the suit property, and learned advocate for the plaintiff, and learned advocate for defendant
Before
number
your
2.
lordship passes the order, may I
Yes.
just try to satisfy
Yes.
your lordship with one point aspect?
Yes.
Your lordship need not give them any liberty. Lordships has stated it. What fell from your lordship, it is the law. They can carry out whatever repair what they needs to, and they can seek appropriate remedies at proper forums. A partition suit is not the forum where a tenants association can come and seek for this.
Okay, you see, in different forums, a plea will be taken.
This
cannot happen here.
Came before this honorable court and got some order
Very
for
well.
certain repairing. And the court, this honorable court has passed that order.
It might be so, but today in this in these circumstances,
So if they carry out the repairs, will you object now?
At their own cost, they can.
No.
At their own
I'll
cost, they
record
can.
that. Yes, defendant
It
number
is
1.
not my learned friend's case that there is no repair works which has been done. The special officer himself has already conducted previously previous
that the-
repair work
that
which
the-
was done.
I have not undertaken.
না, আপনাকে কেন বল- শুনুন কি বলছি, বলতে দাও। Their court has recorded that there were constructions, the repairs, refurbishment work which was carried out. Funds were taken from the position, and it was
That was
explained
when
by the special officer only.
During this proceedings, my lord.
Proceeding,
From
that was by the
2010 to
special officer.
2025.
That was by the special officer.
Your Lordship, at the
They-
very inception, during the pendency of this list, these practices have been carried out previously. Your Lordship, suddenly now he has an
But that
objection
cannot be the
from-
norm. No. That cannot be the norm.
Learned advocate for your defendant number 2.
I am for the defendant number 2.
This application is made by the applicant tenants who are residing at the suit property. 2, with a prayer for a direction upon the learned special officer for carrying out necessary repairs and maintenance work of the suit premises out of joint family funds. Stop. And for an order directing the special officer to take necessary steps to maintain and carry out necessary repairs at the said premises. It is the contention of the petitioner that rents which are being collected from the petitioners includes commercial taxes and maintenance charges and rent bill, with detailed bifurcation and or breakup issued by owners and also previous special offices. It is also contended that various orders have been passed by this court in the suit from time to time. We should reflect the deplorable and dilapidated state in which the said premises is containing to exist. Stop. It is also contended that till date no effective repair work has been carried out in the said premises. Learned advocate for the plaintiff, although does not object the grant of relief, but an objection is raised by learned advocate appearing for the defendant number 2 on the ground that this order may not be passed and the applicants may move the forum to obtain necessary orders. It is an admitted position that as a partition suit is pending and during the pendency of the suit, there cannot be any alteration of the structure of the suit property, but essential repairs may be carried out.
Yes.
As the right to live in a conducive condition is a basic right, and no persons can be compelled to live in a dilapidated building with risks and hazards. Thus, this petition should be allowed. However, the tenants association stroke applicants may carry out the necessary repairs in the presence of the special officer at their own costs, but they can recover the costs in accordance with law from the landlords of the suit property. Don't give the copy of the notice of motion.
My lord, one paragraph, may I
Yes.
show you, lordship? This is annexure D, I believe. Yes, page 20, annexure D. It's a page 22, inner page, my lord. Second paragraph. Running page 3, my lord, your lordship.
Page
Justice
22? Yes.
Shomensen's order, my lord.
Yes.
My lord, in the second paragraph, in a partition suit, so long the shares are not declared, the suit properties are required to preserved so that ultimately when the partition is passed, none of the co-sharers are in a disadvantageous position. In the event no interim order is passed in a partition suit, there is every possibility that co-owner and co-sharer would deal with the properties which ultimately would cause serious inconveniences and
Yes, that is
prejudice.
why interim orders are granted in partition suit. Anyway, no question of alienation or parting with possession.
The injunction is there.
Yes, that is there.
Yes.
Only essential repairs.
Yes.
Your Lordship will just record one thing, page number 34, the notice of the KMC that the building is in delay.
Anyway, that is not
Very dilapidated, my lord. Your lordship kindly. Otherwise, it will come up and if the posta OC inspector is calling me up, the councillor is calling me up.
Let there be an order in terms of the notice of motion. Let there be an order in terms of prayer B of the notice of motion dated 16th day of May 2025. Stop. It is hereby clarified that necessary repairs be commenced upon prior notice to the learned special officer and upon furnishing the schedule of the repairs to be made in the suit property.
My lord clarifies that it should not be out of the funds of the estate. That only I am.
I have made it there at his own cost, but he has a right to recover in accordance with law.
Your Lordship allowed prayers in terms of notice of motion B.
Yes.
That is why I'm
No, in prior paragraph it is clarified that out of his own funds. And by the by the own funds of the petitioner's applicant, subject to the right of recovery from the co-owners in accordance with law.
Your Lordship,
Very well, since you
your Lordship has passed that order, but since perhaps subject to correction, your Lordship has recorded my learned friend's objection with
Yes.
respect to maintainability. I'll just satisfy your Lordship for your Lordship's conscience, page number 24, Justice Orijit Banerjee's order, 20th March 2017. His misplaced objection with respect to maintainability is taken care of over here.
No, I have recorded after recording the objection, I passed this
Okay,
order.
HON'BLE.
Yes, this was GA43 stands.
Lordship is disposing it off.
Yes.
With the objections, I have not used any objections to the affidavit. Kindly record
Okay,
that.
actually, just one minute.
Whatever has
As
been
the
said-
affidavit in opposition is not filed, the allegation
the defendant
in
number
the read petition, a allegation in the application are not deemed to be admitted.
Very well. Grateful.
No, no, disposed.
Item number 21. Well, this was fixed for the purpose
I
of
had
filing.
finished submissions. Learned
Mr.
friend
Sen had
got to
also.
file our written notes, my lord. I could not finish.
GA21.
My lord, if my lord gives me till next week to file my notes.
GA2.
Yes,
GA2.
GA2, yes, GA2.
Your application.
Yes, my lord, that application for production
Otherwise,
of a
your lordship has
document
heard
from the
us.
Office of the Registrar of Companies. Mr. Shakoshan is leading me, my lord.
You have filed your written notes.
It was to be filed today. I'm carrying it, my lord. And there were
today, my lord,
Let
I'm
Mr. Ghosh
seeking
file his written notes on some other day.
Very
1
well.
week's time, if my
My
lord.
lord, may we file our written notes,
Yes,
my
yes,
lord?
yes.
And my lord, in the written notes, since
I'll get hold of it.
very well, we file it on the same day. Lordship keeps it next week any day.
Okay, learned advocates for
I'm
the
grateful.
parties are present. Mr. Ghosh, learned advocate for the plaintiff files time, prays for time to submit the written notes of arguments. Such prayer is allowed. Let this matter appear for arguments on
For filing written notes, my lord.
for arguments.
Arguments over.
It'll appear as-
Okay.
Or let it come as to be mentioned unless my learned
Yes,
friend
to be mentioned.
So matter is not to be argued any further.
Mr. Sen had said he will only
Okay,
formally
let this matter
distinguish
appear
Mr.
as to be mentioned on 11/7/2025.
Great.
11 July.
Great.
14 ko 11 is again.
11th of July.
My lord, 14th instead of
Okay.
14.
14/7/2025.
Has to be mentioned.
Has to be under the heading.
mentioned. Written notes of arguments to be filed on the said date.
I'm
Grateful, grateful.
14.
22, my lord, this is my application. I am the defendant number 1 petitioner before your lordship.
GA9.
My lord, this is a suit for partition. My lord, where, my lord, the plaintiffs 1 to 4 and the defendant number 1 are the children of defendant number 2.
I am for the defendant of in the G application.
My lord, during the, may I indicate the,
Yes. The affidavit of service with notes of.
may I indicate, my lord?
Yes.
My lord, the defendant number 1 is the son of defendant number 2 and the plaintiffs are the daughters of the defendant number 2, my lord. During the pendency of the suit for partition, my lord, a receiver was appointed in the proceedings to collect the rents from the property. With passage of time, my lord, what has happened is the defendant number 2 has got of advanced age and is now, my lord, requiring certain funds. Till now, my lord, both the parties were, my lord, taking care of the ailing mother. My lord, because substantial sums are lying with the receiver, my lord, there is a direction with the receiver to file reports. None of the has come to me, nor to my learned friends, I understand. My lord, your lordship would kindly consider, my lord, page 19.
No, fund. What fund is lying with the receiver?
My lord, the rents and profits, my lord, of the, your lordship would kindly see, my lord, page 29 for once. Page 29, my lord, the order of 12th of August 2013. My lord, the case of the petitioners, my lord, may I indicate that? Jointly owned such and such share in the property, the share of the defendant number 1 and 2 will be collectively lesser than the plaintiffs. The petitioners are such and such. My lord, kindly come to the next paragraph. Accordingly, Mr. such and such bar association is appointed as a receiver for the purpose of making inventory with report with regard to the persons in occupation of premises and file it on the next date. My lord, thereafter, your lordship would kindly turn the page to page 31. Report of the receiver, my lord. The order of 26th August 2013. Report of the receiver is kept on record. From the report of the receiver appointed by the order of such and such, it appears that a sum of rupees 43,143 is collected from the premises in question. The receiver appointed is directed to collect rents, issues, and profits in respect of the
Just
said
a minute.
premises.
আমার আর ডেলিকে একটুখানি পাঠিয়ে দিন, হ্যাঁ, একটা কথা বলতে হবে। যে পিএসও আছে না, বিশ্বজিৎ, yes,
My lord, your lordship, my lord, would then, my lord, by this order of 26th August, my lord, the receiver had collected the rents. My lord, then the subaltimate paragraph from the bottom, the receiver will be entitled to a monthly remuneration. Directions are given for filing of affidavits. My lord, then 9th June, my lord, the learned receiver's remuneration was substantially increased to a certain extent, which is of 9th June, my lord, at page 32. And my lord, page 33 is important. Page 33, the bottom, my lord, the receiver shall submit the accounts on periodical basis in the department. My lord, as of now, my lord, your lordship, if kindly turns over the page, these, my lord, are the prescriptions of the defendant number 2, my lord, the mother of the parties.
mother of the plaintiff and
The defendant number 1 and the plaintiffs. The plaintiffs are 4 sisters and the defendant number 1 is the brother. Defendant number 2 is the mother of all the parties.
So for incurring expenditure of defendant number 2,
Defendant number 2, medical, my lord.
medical,
She is now, my lord, above 80.
some fund is required.
Some fund is required, my lord.
My lord, I am for the defendant on the G application. I'm in the suit. I'm the plaintiff, and the G application. I'm the defendant. I laid by my senior Miss Setu Dasho. She could not be present today because of she's suffering high fever and cough and cold. And
Come on Monday. If he's unable to come on Monday, you come ready.
I sought time for filing opposition. My lord, G application.
You are opposing this application.
This is my instruction from my senior.
Okay, then let a short date be given.
My lord, your lordship would kindly consider the age and
Yes.
my lord.
Learned advocate for the
Okay, down now.
plaintiff, for the defendant number 1 petitioner, and learned advocate for the plaintiff.
Plaintiffs.
Plaintiffs are present. This application GA 9 of 2025 is taken up for consideration. As learned advocate for the plaintiffs sought leave to file affidavit in opposition. The affidavit in opposition may be filed by (9/7/2025). 9th of July.
3 weeks time, my lord, I need.
Okay, 17/7/2025.
Jobless. I'm grateful, my lord.
Reply, if any,
A week thereafter,
by 24/7/2025.
my lord.
Let this matter appear on 25/7/2025.
My lord. My lord, I'm deeply obliged. Deeply obliged.
My lord.
My lord, I'm appearing for the applicant in this matter. This is my application for
was
stepping into
respondent.
the seeking for an amendment of the plaint.
GA?
GA 1179 of 2017, my lord.
That is the old number, new number, I think.
GA4.
The
GA4,
new number is
GA4.
GA4, my lord. There has been some amalgamation that
Pending
has
from
taken.
2017.
My lord,
Affidavits are filed on this application.
No, I have not
my
seen
lord,
it.
last day your lordship had indicated, and as
I have not seen, my lord. That
my
GA
lord,
application.
service has been done. We are carrying the proof of service upon the defendant, my lord. We have served upon
Defendant,
the
my lord, the
defendants as per the
defendant is the post
instruction of your
office.
lordship.
Dependent is a post office here at Citations Avenue, but actual address is Middleton Street. They serve it here, so we don't find a copy, my lord.
Anyway,
That's
let a copy be served. Let him come ready on the next day.
My lord, may I just only move my application today, my lord? Only thing is
No,
that
unless I
as
get
we-
a copy, my lord, how can it, my lord?
my lord, we have served the same upon the Union of
Yes.
India and the Joint Secretary.
But from
My lord.
17 it is pending, 8 years. Now let them have another 2 weeks.
GA, GA, this 4. Yes, record an order. Learned advocate for the plaintiff applicant and learned advocate for the defendant are present. Let a copy of GA4 of 2017 be served upon learned advocate for the defendant. Let this matter appear on 1/7/2025. Let the record of GA4 of 2017 be put up.
My lord, may it be kept at the top, my lord. A humble request, my lord.
Okay, let this matter appear within first 5 matters.
So grateful, my lord.
Here.
The defendant, my lord,
My lord, I am appearing for the plaintiffs, my lord. I'm being led by Mr. Rupak Ghosh, my lord. This matter was made returnable yesterday, my lord. It was fixed at 12:30, my lord. My lord, Mr. Ghosh is in some difficulty today, my lord. I was only praying if this matter could be heard on Monday.
I'm for the petitioner, my lord. Your lordship will
Your
recall.
application, this GA11.
Yes, plaintiff number 10.
Yes.
My lord, your lordship will recall this is
My
a
lord,
matter
we were to reply today.
drawn according to my client's case without his knowledge and behind his back. As a result,
Matter was hard.
yes, from time to time, my lord, your lordship has been pleased to hear the matter.
Yes.
And my lord, today I thought that I'll be finishing my argument and thereafter they would commence. My lord, your lordship had directed us to file a written notes of argument.
Notes of my lord.
Written notes and list of dates.
Yes, my lord. That if my learned friend is wanting me to continue with my submission, I'll take hardly 10 to
My lord,
15. My learned friend
my lord, I
can
was only praying, my lord. My lord, Mr. Ghosh would be addressing your lordship, my lord. We were to reply today. My lord, it was fixed yesterday. I was only praying, my lord, if it could be returnable on Monday, my lord, we'll make our submissions.
Mr. Ghosh can always give his reply on the next.
My lord, just a days. My lord, I'm just praying for a day.
So will he come ready on Monday?
Yes, my lord. Yes, my lord. We'll file. My lord, we'll reply on Monday itself, my lord.
My lord, your lordship was pleased to give me some more time to complete my submissions because there are certain notices that I was about to show to your lordship on the ground that we were not intimated with regard to the final decision that was taken for withdrawal. For that, your lordship was pleased to direct us to indicate as to how we have dealt with the 2 notices that we have received, and our cases, the 3rd and 4th notice, on the basis of which that they have withdrawn the suit according to them, was not at all intimated to us. So these 4 notices I am yet to bring to your lordship's attention.
So you have dealt with in your application
and
as well as in reply.
Yes, yes, that I have dealt with, and
you have
also
taken care of it in your written notes also.
that I have. I have. May I have a copy of the written notes? My lord,
I appear for the defendants in the suit, my lord. We have compromised with the plaintiffs, my lord. Mr. Rupak Ghosh was appearing for the plaintiffs, apart from plaintiff number 10. Well, if a copy of the notes of Mr. Hon'BLE Ghosh can be please made over to us, we'll also address your lordship on how, my lord, Mr. Ghosh's client has duped us, and my lord, as of now, is putting a spanner in the wheel.
Mr. Ghosh,
the
yes.
settlement.
Yes, on the next day, please appear physically. Otherwise, it is
Yes,
becoming
yes,
convenient.
my lord, both Mr. Rupak Ghosh and I will be there.
We'll exchange the notes because it was only for your lordship's convenience. Your lordship had directed us.
Yes.
They are not filing any notes.
Let the notes be exchanged. You appear physically on the next
Yes,
day.
yes. When they are going to give us the notes, we'll exchange. My lord, then let me keep
My
the
lord,
note.
we've not made our submissions yet. My lord, I was only praying, my lord, we'll make our submissions and we'll file our written notes. Mr. Rupa, my lord, he's not started yet, lord. He's not made his submissions yet. In reply to Mr. Senior Advocate, Mr. Shanindu Ghosh's reply, my lord.
No, Miss Senior Ghosh has not yet completed.
Yes, my lord,
Yes,
10 more minutes.
Senior Ghosh
Yes,
is
my
yet
lord.
to complete.
Yes, my lord.
they'll-
After Mr. Ghosh
thereafter they'll
completes,
comment.
we'll address.
We'll take the notes today. We'll take notes of what my learned senior is saying.
Yes.
And we'll inform. I'm led by Mr. Shomabo Ghosh. I'm sure he's led by Mr. Rupa Ghosh. We'll inform them. We'll come back on the next day and reply.
On Monday.
Majority of the decision, majority of the argument of my client has already been completed. It's only that, my lord, if your lordship kindly has a look at the notes, my lord, we have tabulated.
Yes.
We have tabulated the notices.
Can we get a copy of the notes, my lord?
No, my lord, not right now. It's only for your lordship's convenience. My lord, whenever they give us the notes, we'll exchange it with you. My lord, if your lordship kindly comes to page 16.
Page 16.
Yes, my lord, of the note. My lord, this is only with regard to the 4 notices. My lord, their case has been that in spite of our being served with notices, we have not appeared in the meetings, as a result of which, my lord, we have on our own kept ourselves apart from the date when the resolution was taken with regard to withdrawal of the suit. Our cases, out of the 4 notices, 2 notices were issued to us. We did not appear for reasons that we have stated in the reply. And the last 2 notices, which has resulted and culminated into this resolution for withdrawal of the suit, was not given to us at all. So, my lord, we have tabulated the 4 notices. If your lordship kindly comes to page 16. We have also indicated, my lord, the pages where the particular document would be appearing. My lord, notice was given, my lord, on 28th of June 2023. Your lordship kindly sees the last bracket on page 16.
Yes.
The notice is 28th of June 2023, my lord, which has been replied to by my client by a letter dated 5th of July 2023, my lord, and the letter will appear at page 277 of volume 3 of the affidavit in opposition, filed by Somshankar Mukherjee, volume 3.
That is plaintiff number?
I'm plaintiff number 10.
No, this affidavit in opposition.
Somshankar is plaintiff number 9.
But this is 2?
My lord, this
Page?
My lord, 277 of the affidavit in opposition by Somshankar.
Yes.
My lord, first paragraph, my lord, I'll not trouble your lordship with that. Yes. My lord, the notice which was never served the my lord, first may I just show the notice, my lord. That
Page
is in the
277.
my lord, yes, that is the answer to the notice affidavit. My lord, if your lordship kindly comes to the affidavit in reply to Somshankar's affidavit in opposition, then my lord, it will be affidavit in reply here to Somshankar's opposition. Yes. The 1-line notice. My lord, the notice is given to my client saying that there will be a meeting on the 30th of June 2023 at such and such time. To this, this is, my lord, very important point is that it is being written by Shom Shankar Mukherjee, who poses to be the one who's representing all the plaintiffs.
Yes.
My lord, to this, the reply is appearing at 277 of the third volume of the affidavit in opposition.
277.
Yes, my lord. I just indicated prior to showing this notice. Annexure G. I'll not trouble your lordship with the first paragraph.
277, yes.
Your lordship has got it, my lord, Annexure
Yes,
G.
yes,
My lord, if your lordship kindly comes to the bold portion. If I'm not wrong, Mrs. Shonali Roy already disclosed by an affidavit in a court proceeding that you already transferred your share in her favor thereon the date of issuing the instant notice of such and such. How can you address yourself as partner of the firm of Mrs. Ashutosh Roy, Prafulla Kumar Roy? This is the question form, my lord. What my client is wanting to hint at is that you do not have the capacity to write the letter or notice with regard to holding the meeting, inasmuch as your share has already been transferred and you're no longer a partner. That was one of the main objections. Will you be in a position to call any meeting for the firm? Then next, my lord. Hopefully, you are aware that I have filed one arbitration proceeding against Mr. Shonali Roy and others, and the said proceeding is going on since 2020. However, between 2021 to May 2023, you totally got yourself silent about the same. I really want to know in this juncture what is the deal. My lord, all this is not quite necessary. It's only that, my lord, that paragraph 4 says that there is no agenda for the said meeting. So, my lord, there is no hint with regard to the suit getting withdrawn as on that date. As on that date, the hint was
except intimation of the meeting.
Only intimation of the meeting by a person who was no longer a partner then.
Without enclosing the agenda.
Yes, my lord, without enclosing the agenda and by a person who was no longer a partner then. That is, my lord, with respect, a very important point for which we felt that it was not necessary for us to attend the meeting because he does not have any right to issue a notice. My lord, that was the reason why we did not appear there. Okay. My lord, there has not been any reply to this letter. Your lordship will kindly note, no reply has been given to this letter. Then, my lord, your lordship will kindly take the next bracket. That is a notice of 12th of December 2023. This will appear again at pages 67 to 70 of that affidavit in opposition, which has affidavit in opposition, which has been affidavit in reply. Okay, to the affidavit in opposition. My lord, I have handed over that affidavit in reply. You're the same bunch, my lord. Your lordship will kindly see.
Page 67.
67 to, that will be. Oh. Yes. My lord, page 64 I had shown. Then, my lord, page 67. This, my lord, has been issued by Parup Kanti Mukhopadhyay. Your lordship will kindly note, Shom Shankar is not giving the notice. Shankar is not given. We have challenged the status of Shom Shankar.
This is in volume 1 of the affidavit in opposition.
No, my lord, the reply I had handed over, page 64, you had just, my lord, your lordship was pleased to see.
4 of the reply.
Now, my lord, page 67.
Just a minute.
The lordship will be pleased to keep only this volume 3 and the reply. That is these two documents.
Page 67.
Yes, my lord. Now, my lord, the signatory is Swarup Kanti Mukhopadhyay. Your lordship will kindly see the change. I had challenged the capacity of Shom Shankar. Next notice is not by him. This has reference to the letter dated such and such issued by Shonali Roy in respect of firm this. I hereby inform you that I am presently under some financial distress and also suffering from health ailments, for which reasons I shall not be in a position to participate in the business of the partnership firm. Accordingly, I request that a meeting of the partners to be held at the office of the firm at such and such for the purpose of deciding the course of business of the firm. No whisper with regard to the suit getting withdrawn. Again, no whisper. Then, my lord, the reply to this has been given by my client by a letter dated 14th of December 2023, immediately one day thereafter, which will appear at page 295 of volume 3. My lord, the volume that I had just shown to your lordship, 295. May I?
Yes.
And my lord, strangely enough, the notices have not been disclosed by them in their opposition. My lord, if I may read out only the important paragraphs. If I am not wrong, Mrs. Sonali Roy already disclosed by an affidavit in court proceeding that you have already transferred your share in her favor. Then on the date of issuing the instant notice, such and such, how can you address yourself as a partner of the firm of Ashutosh Roy, Prafulla Kumar Roy? If you are not at all in a position of partner of the firm, then how can you call any meeting for the firm? Hopefully you are aware that I have filed them and the same thing has been repeated. My lord, the main thing that my client wants to emphasize on is that, again, you are not a partner. So how can you possibly have the right to issue the notice? So previously, my lord, it was issued to Som Shankar. Now again, this is being issued by the other partner. They both by that time had transferred their share. So that was the specific reason why we did not, my lord, attend the meetings.
So this is the opposition. They have annexed this letter.
Yes, they have annexed my reply.
Yes.
But they have not annexed the notices that they have issued, showing that the notices had not mentioned anything about the withdrawal. One is only mentioning that there will be a meeting, no agenda, nothing. The second is saying that I am ill, as a result of which I am not to continue with the proceedings. You please come, there should be a meeting. But that they are going to withdraw the suit, there was no whisper about that. And my lord, I did not attend because they were not partners, those who had issued the notices. So I felt that they did not have the right. Now, my lord, your lordship will kindly come to the next document, which appears at page 302 of the same volume, my lord. 302 of the volume that your lordship is having in your lordship's hand. Of 2025. Yes, your lordship will kindly see. Your lordship has got, my lord, 302. My lord, this is the minutes of the meeting. Minutes of the meeting in which, my lord, I'm not there. I'm not there. Yes, your lordship will kindly see the agenda. The meeting has been convened for the purpose of discussion for proper management and operation of the business of such and such and such and such. On account of the continuous delay in collection of rent, my lord, I had, my lord, brought it to your lordship's notice on the last occasion that from the clause of the partnership firm, it appears that the business of the partnership firm was to collect rent. So, my lord, here it appears from the minutes, delay in collection of rent and growing anxiety between the tenants. So that was the main purpose of the partnership firm for collection of rent. It is unanimously decided that Som Shankar Mukhopadhyay shall continue to collect rent on behalf of the partnership firm. He has informed that he is in the process of recovering the authorization given by all erstwhile partners in his favor in the suit before the Honorable High Court. Rent receipts of previous months, rent collected as per the terms of settlement dated 20th June 2023 has not been circulated on account of the checkbook and the rent receipts not being signed by Sujoy Mukherjee. My lord, then we come to the agenda number 2, agenda number 3. My lord, I'll not trouble your lordship with all this. My lord, only this agenda number 3, if your lordship kindly sees. Agenda number 3.
Yes.
Mr. Somshankar Mukhopadhyay informs that no steps have been taken in the suit before the Honorable Court after COVID-19 and regular change of Honorable Judges, changes judges. Since it is a matter of final hearing at this stage, it will not be possible to have the matter heard. There is also substantial sums outstanding as legal fees, which has to be undertaken by the partner or from the firm's account. At this stage, the partner should take legal advice whether to proceed with the suit. Several litigations involving firms initiated at the instance of the partners have completely depleted the account of the firm. Unless any further money is brought into the firm, it cannot be proceeded with the litigation. But still, my lord, as on that date, they had not, my lord, passed any resolution with regard to withdrawal. Then, my lord, your lordship will kindly see.
She will kindly read agenda 4 and 5.
Yes, yes.
My learned senior friend would.
Yes, I will. I will read out. 4. Oishwarya Rai and Somshankar Rai shall take steps for ascertaining legal advice in the matter as to whether to proceed with the litigations of the firm and if the partners can continue. 5 is legal advice shall be sought to ascertain course of action against Sujoy Mukherjee for his anti-company activities, that is my client, and effect on the terms of settlement dated 20th of June 2023. It is agreed by and between the parties that a meeting shall be held either on Thursday or Saturday in the first week of January 2024 upon mutual agreements of the partners appearing in the present meeting. My lord, this notice of this meeting was not served on me, as a result of which I was not there as a party. There was no, my lord, resolution that was passed with regard to any withdrawal as on that date. No resolution.
Only lawyers, only a legal advice, whether to continue or not.
Whether to continue or not, legal advice was to be taken. And my lord, again, your lordship will kindly see, the Somshankar Mukherjee was at that point in time, again, not a partner. Again, not a partner, my lord. I have stated that long back. He had transferred his share to Sonali Rai. He and his father, both the signatories of the previous 2 notices, had by the time transferred their share. But however, my lord, they continue to act as partners of the firm in spite of their share having been transferred. My lord, I could not, and I did not have any intimation with regard to this proceeding, as a result of which I was not there. Next, my lord, your lordship will kindly come to the last notice, which, my lord, would appear at page 304. That is the last minutes of the last meeting. May I read out, my lord? 304, your lordship has got it, my lord. Here again, I have not been served. I will not take much of your lordship's time. I'm holding up your lordship for long. Present meeting is held in furtherance of the meetings held between the partners on 16th December, 20th December, where it as was decided between the partners. Despite attempt to communicate with Sujoy Mukherjee, he has decided neither to respond to any attempts at contacting him, nor taking any steps in the partnership firm business. Meeting could not be held in January 2024 due to non-availability of some of the partners. Your lordship will kindly see the mystery presentation. There is no whisper of my client having immediately replied within a day, saying that the signatories are not partners. By that time, they had already transferred their share.
No, one signatory is not a partner. That is probably these 2.
Both the part, both.
Serial number 2.
No, my lord, Somshankar and also my lord, his father.
So for Sonali Roy, he has.
Yes, she is there.
Yes.
Somshankar
was not a partner.
Somshankar by that time was not a partner. And my lord, 6, Swarup Kanti Mukhopadhyay.
His father.
Yes, his father was not a partner. And these are the 2 people, those who had issued the notices. Immediately I reacted to that, having said that you are no longer a partner, you are transferred. There is no mention of that.
Did they dispute that in their reply?
No, they have not replied to this. They have accepted it. My lord, Sonali Rai in an arbitration proceeding before the honorable arbitrator has been pleased to state that on oath, that she has got the rights of these 2 people. I got to know it because I am a party to that arbitration proceeding, and on that basis I intimated them that how can I accept your notice you're no longer a partner. My lord, the misrepresentation is that despite attempts to communicate with Sujoy Mukherjee, he has decided neither to respond to any attempts at contacting him or taking any steps in the partnership firm business. There is no mention of the fact that I have immediately replied and I've challenged their authority. And that is the reason why I have not attended the meeting. Having had given this impression, wrong impression to the other partners, my lord, they have continued with the meeting. Now, my lord, your lordship will kindly see the agendas, whether any of the agenda says that the suit will be withdrawn.
Yes, which page? Oh, this agenda 2.
Yes, my lord, 304.
Yeah, 305. Okay, 304.
304, I'm continuing, my lord.
Agenda 1.
Yes. On consideration of the legal advice and perusal of legal documents, it is agreed between the parties present at the meeting that rent shall be collected from the tenants by Somshankar Mukhopadhyay, and he is jointly authorized to collect rent by all the partners present at this meeting. So this gives an impression that the business of the firm was allowed to be continued by Somshankar, who, my lord, was not a partner according to me. But then there was no whisper that the business, my lord, then your lordship will kindly see that the business will come to an end. Then agenda 2. It is between the parties that all endeavors shall be undertaken to resolve disputes and legal proceedings against partnership firm and amicable settlements and taken steps for recovery of dues and or generate income of the partnership firm. Further, the tenants shall be approached for the purpose of increment of rent, which goes to show that the partnership firm...
The partners have resolved to take steps for settlement of the dispute.
Settlement of the dispute with the tenant.
No, settlement of the disputes.
Yes.
Or is it all disputes? Resolve disputes and legal proceedings against the partnership firm.
Right.
Suppose there is a suit against the partnership firm.
Yes, my lord.
But whether it comes by the partnership firm, whether the partnership firm is the plaintiff, whether it includes that or not.
Agenda 3 would be.
Yes, I will come. I will come. I've got it in my presence.
Yes.
Then, my lord, your lordship will kindly see the agenda 2, the last line. Further, the tenant shall be approached for the purpose of increase of rent.
Yes, that is there.
That is there?
Yes.
And my lord, agenda 3 is where they come with regard to the withdrawal. Then your lordship will kindly see agenda 3. Further, it is agreed that since the suit filed before the High Court at Calcutta being CS number such and such, the instant suit should be resolved as the other parties have neither contributed to the litigation cost, nor can the proceedings be borne by the partners herein. Expenses of the suit has become protracted and onerous on the partnership firm. Therefore, it is unanimously decided that the suit be withdrawn by the constituted attorney appointed on behalf of the partners. Somshankar Mukherjee is authorized by the partners to take steps with the advocates Chatterjee and Seal Company for the purpose of withdrawal of the suit. It has been informed by Mr. Mukhopadhyay that despite approaching the advocates, he was not handed over papers and documents on account of absence of the proper authorization. The said advocates have failed to proceed with the matter and has refused to entertain the requests of the partners on flimsy grounds. If required, Somshankar Mukhopadhyay shall appoint new advocates in other proceedings to represent the partnership firm, to the exception of Chatterjee, Seal and Company. However, your lordship will kindly see from the order that was passed, my lord, by my lord on the 2nd of May.
This is agenda 3.
Yes, agenda 3.
Okay.
Impression is being given that Chatterjee Seal, who was representing all the partners, my lord, is not cooperating, as a result of which they are taking steps to appoint someone new.
Yes.
No, that impression your lordship is getting from this minute.
Agenda 3.
Agenda 3, that they are going to appoint a new advocate and record, in as much as the old advocate and record is not cooperating with them on flimsy grounds. Now your lordship will kindly see the order once.
No, now the question is, you see, agenda 3, therefore it is unanimously decided. So, question is, decision is taken where?
And whether it is unanimous.
Unanimously decided. That means it is mentioned in the agenda.
Minutes. It's in the minutes.
No, okay. This is the minutes.
Yes, this is the minutes.
It is unanimously decided.
They have decided, these people, in my absence, without giving me any notice, giving the representation that in spite of giving notice, I'm not coming.
In the notice of meeting, this agenda of withdrawal of the suit was not there.
Never mentioned. First of all, last two meetings, my lord, of which the minutes have shown, no notice was given to me. I was given notice with regard to the first two meetings that I had shown, of which, my lord, there was no whisper of any withdrawal. I did not attend to those meetings on the ground that the signatories were no longer partners. I refuted and I had expressed my mind as to why I'm not attending. They have not mentioned that in their minutes. On the contrary, my lord, having given a wrong impression altogether, they are saying at page 304 to the other partners that despite attempt to communicate with Sujoy Mukherjee, he has decided neither to respond. My lord, I put a question to myself, is it not a blatant misrepresentation? I responded immediately within a day. 12th I received, 14th I responded.
So first and second mode meetings, you did not receive any notice.
I received. First and second I received.
But you have challenged the authority of
challenged the authority
of the signatory. And this is the third notice.
This is the minutes.
This is the minutes of the second.
Fourth. There are four. My lord, the third one is appearing at 302, the minutes.
Yes.
And the fourth is at 304.
304.
304.
So first and second notice, you challenge the authority of the signatory.
I challenged.
And no question, no agenda was there regarding withdrawal of the suit.
No, my lord. And neither have they replied that no, we are partners. In that whatever you're challenging is
challenge
incorrect.
The authority.
Nothing.
First and second. Now with regard to third notice?
Third, there has not been any notice.
Third, there is no notice.
There's no notice.
But there is this is the minutes.
Minutes.
And the fourth one?
No notice, minutes.
Okay.
Two, I have received notice, I've challenged, and your lordship will kindly see one interesting fact. The first signatory is no longer the second signatory. I challenged his authority, the signatory is someone else. I challenged again his authority, no notice thereafter. But on their own, giving an impression that I have not been responding. I have responded within a day. Nothing has been written with regard to that. Total misrepresentation made before the other partners. Number one. And secondly, again, my lord, unanimously decided. I have been totally left in the lurch. Again, my lord, that question of majority decision will come. That, my lord, a judgment has been placed by them. I have adequate points to distinguish the judgment, and that majority concept will not apply until and unless this decision is taken with regard to the management and continuation of the business of the firm. Withdrawal is not the business of this firm.
Yes, that is the point of law.
That, my lord, I will argue at the next sitting, my lord. If at all, in the time of argument, I reply. My lord, my learned friends can commence their argument at the next sitting. My lord,
yes.
I'm deeply obliged
so
to
you
your
will
lordship.
Continue on the next day.
First, the plaintiff, we are the defendants, my lord.
So Mr. Rupak Ghosh, the next date, he will start, make his submission.
Thereafter, the defendant.
Thereafter, the
Yes.
only request would be, lordship, the matter was fixed yesterday at 12:30. If lordship could also fix another date whenever lordship's giving.
Yesterday it was fixed.
At 12:30.
Yes, yes.
So if next day when my lodge is fixing,
Okay.
could be a time matter, lordship.
Learned advocates for the petitioner. Your plaintiff number?
I'm plaintiff number 10.
Plaintiff number
And
10.
My lord, I am on behalf of all the other plaintiffs through the authorized representative.
Concludes his submission on GA 11 of 2025. The case stands adjourned to (16) 7/2016
As you
7/2025 at 12:30 p.m. for the remaining plaintiffs who are opposing GA 11 of 2025 to submit. Let the written notes of arguments filed by learned counsel for the petitioner plaintiff number 10 be kept with the record.
And we'll exchange, my lord. Once they give their note, we'll exchange.
If you submit the notes, it will expedite.
Lordship, only thing Lordship has said plaintiffs only, plaintiffs and defendants would respond.
First, you see, plaintiffs will have their stand,
Then we'll
defendants
come.
will have
Then
their
we'll
stand.
come.
Let the plaintiffs make the submissions.
We'll try to prepare the written notes also.
And my lord, your lordship will be pleased to give me liberty to distinguish the judgment after they finish, my lord. If there is any other judgment.
Whatever is that, you do it in your reply after the plaintiffs and
Yes, in
defendants
my
have
reply, only
completed.
point of law.
Yes, only on the points of law.
Yes,
I'm so grateful, man.
grateful, my lord.
16.
Your Lordship was pleased to take up item number 13 in the morning today, Your Lordship. Mr. Sinha was put this.
Item 13?
Item 13. This matter will be kept next week. The state's application is also required to be turned over on that day.
Okay, 13. This is item 25.
It's item 25.
Acha. Item 25. Okay, let this matter appear. Item 25, learned advocate for the state and learned advocate for the defendant are present. Item 25. Let this matter appear on. Yes, when was the last matter fixed?
First of July.
Let this matter appear on 1/7/2025.
Pilot item number 26, I'm for defendant numbers 1 and 2.
I appear for the plaintiffs.
The application is by the plaintiff challenging the report which has been filed by the valuer. On the last occasion, your lordship had directed the valuer to remain present.
Yeah, the lawyer, I believe the
Yes,
valuer is present.
I'm told he has come today to court. Kudhar?
Yes.
My lord, he is there, the valuer.
Lordship, it is my application, my lord. In this application, we have taken certain exceptions in the way of that certain negative points with regard to the property have not been considered in the valuation report, as well as there's some.
You have taken the exception.
Yes, my lord. So
are you accepting the valuer's report?
I am accepting. So far as the defendant numbers 1 and 2 are concerned,
You are opposing his application.
I am opposing his application.
And
But
for that, you have taken out an affidavit also?
yes, affidavit in opposition is already filed. It's on record. The points which have been urged, if my learned friend places what I had indicated on the last occasion, because it's the valuer's report and it's a specialized subject, the valuer should be there. And on my prayer, your lordship had directed the valuer to come.
On the
Because
last
he
occasion-
has to defend at the end of the day his report which has been filed.
Yes.
Lordship, the other defendants, that is the defendant numbers 3 to 9, had also paid for to file their affidavit in.
But they are not present today, and
They are not present today. However, the
Defendant number
value-
3 to 9 are appeared on the last occasion?
yes, the last occasion a lady was
and-
appearing.
Yeah, and there was a direction.
You are for defendant number?
1 and 2.
So let me fix another date.
Lordship,
My lord,
the lordship in the
because
meantime,
the
what I,
valuer is there, I think it is
Lordship
best
should-
if my learned friend begins, because the valuer ultimately has to
Lordship,
his report.
Lordship, let the valuer come up with his reply with regard to the.
So have you
points-
served your
Yes,
exception
yes,
to the
yes, my
valuer?
lord. Yes,
It,
yes.
it is not my respectful submission before your lordship. Your lordship will kindly consider. Report is already there. Your lordship can call for from the valuer, because he's personally present today, whether he has anything further to add to what is already there, or according to him, he stand by his report. This clarification, at least if your lordship gets.
Let me grant him some time. Okay, he has received that exception. Okay.
Long ago, this application is of 23.
Yes.
This
he has-
application is of 2023.
And he should be given an opportunity to reply to the exceptions which have.
Let us understand whether he is at all asking for time before your lordship to file an affidavit or something or the other. Because he's present personally. He might be. Ashun, Shamne, Ashun.
You can touch.
Yes, you have received a copy. You have submitted your report. And they have taken an exception that they don't agree. Okay. Did you receive the copy of that exception?
Yes, I have received the copy.
So do you want to state anything further clarifying your stand in writing and clarifying your stand with regard to the exception and with regard to the report?
According to me, every details has been incorporated in the report.
No, regarding his exception, do you want to clarify anything on the next day? I can grant you time if you want to clarify with regard to the exception, because he has not accepted your report. So that is why he has taken an exception. Do you want to clarify anything with regard to the exception? You consider your report and consider his exception. If you want something to be clarified, you can clarify on the next date.
Okay, it will be helpful if.
Okay.
Time is granted.
Learned advocate for the plaintiff and learned advocate for the defendant number 2.
1 and 2.
1 and 2 and learned valuer are present. As copy of the exception is already served upon the valuer, and opportunity is given to the valuer to clarify as to whether he has to make any comments with regard to the exception filed by the plaintiff. The valuer shall submit his clarification with regard to the exception taken by (11/7/2025). Let this matter appear on 16/7/2025.
Grateful to Lordship.
Lordship, in the meantime, he has requested for another copy of the application. We'll serve on him.
Yes, copy of the application for of exception be served once again. So if we let the valuer remain present once more.
Yes.
On 16/7/2025.
Will it be your Lordship's pleasure to fix a time for this matter? Because since the valuer is not an advocate and appearing in person, then he.
আচ্ছা 17 তারিখে কি আছে কিছু ফিক্সড আইটেম? 16 তারিখে তো আছে, 17 তারিখে নেই। একটা 2 PM ফিক্স হলো যে আজকে, না হয়নি 17 তারিখ। Let the matter appear on 17/7/2025 at 3 PM.
Grateful to Lordship at 3 PM. Yes. And if it could be clarified whether he has to file an affidavit along with his clarification before your Lordship to submit.
His report is not by way of any affidavit. Okay.
His report is just a report.
Is just
Yes, the
clarificatory report.
Clarificatory report.
Yes.
Very.
Clarification is also another report.
Yes. Grateful to Lordship.
Copy of application of exception is served upon the valuer.
Lord, my officers are going.
Let me see the last order.
I'm appearing on behalf of defendant number 56.
Yes, on 11 June, the matter appeared, and I granted you time to take necessary steps for collection of the copies.
Yes.
And the matter was urgent till today. So,
my officer visited the office of the CBI, and they have shown the documents. These are the documents. You collect the documents from this bunch and take visit there.
Have you collected the certified copies?
The bunch of documents, we are asked officer
bank officers.
Bank officer.
Yes.
Along with one clerk, he is identifying the document. Thereafter, he is taking documents.
That he has taken.
It is not yet completed. It will take some time.
My instruction is today, just day after, before yesterday they came to our office. They are now verifying the documents. After that, they will come. I think it will take some time. We are ready with the documents to hand over the bank office.
learned advocate for the plaintiff and learned advocate for the defendant and learned advocate for the CBI are present. It is submitted by learned advocate for the CBI and learned advocate for the plaintiff that in terms of earlier order dated 11 June 2025, the plaintiff took inspection of the documents but have not received the copies, and upon inspection of the same, the plaintiff will collect the said copies. Stop. In the facts and circumstances, parties are granted time to complete the inspection and collect the documents.
Certified copy the document.
Collect the certified copies of the documents on or before 24/7/2025. Let this matter appear on 28/7/2025.
Let them identify the documents and they have to produce before the officers. Otherwise, it will difficult for.
It's a voluminous document. We told already.
They are showing documents, my lord. These are the documents you collect from this.
Anyway, I have granted you sufficient time. You can do the needful within this time.
It is pending for last 2 months. They are, we will get to
My petition. This is my application, my lord. Now, Lordship will recall, this is that matter where the defendant has made an application to withdraw sum of money which is lying in the receiver's custody with the Standard Chartered Bank. So now,
yes, I directed the sudden applications be put up.
So this we have served the plaintiff. I appear for the Rashtriya Ispat Nigam Limited, the defendant.
Because you see, it would be easier if the instead of keeping the suit pending, fix a date, dispose of the suit, dismiss the suit, and thereafter I grant you
That has to be done. That has to be done.
Without dismissing the suit.
Lordship will have to do it then, because we have already served the plaintiff. It has been delivered. The plaintiff is not appearing, but the suit is remaining in the records of this court. Now, Lordship will have to dismiss the suit because the plaintiff is not proceeding in the matter.
Yes, let me see the earlier order.
Yes. I order to the Lordship. Now, my lord's last order.
Yes, I granted you liberty to take inspection.
Yes.
And the says these 2 copies, GA40.
Yes. Those copies have come. I have taken inspection.
And file a supplementary affidavit.
Yes, supplementary affidavit is here, my lord. I'll file this, my lord, with the leave of the court, my lord. Now, what I have done, my lord, in the supplementary affidavit, I have annexed these 3 orders. These are so old orders, not available in the internet. So, we have obtained copies from the. It's in a very bad condition, but be that as it may, we have obtained. 3 orders will be clear because we have annexed the general application, the prayers therein. So, what was missing? But what are the orders passed? So orders I have annexed supplementary affidavit.
Yes, let me see that.
Or she will kindly.
Because the date has to be fixed, the suit has to be dismissed, and necessary orders have to be passed.
Maybe that lordship can pass. Now I'll tell you, lordship.
Instead of keeping in this way, the suit has to be dismissed.
Yes, the suit has to be. The plaintiff has abandoned the suit. If I take it up to that extent, now lordship.
Because the moment the suit is dismissed, it becomes your right.
It becomes my right. I will have what all I have to show. Lordship will kindly see the first order. Let's just remind lordship for 1 minute. The suit is for specific performance by the plaintiff with regard to 3 export licenses. There were some waiver schemes by the central government for this specific performance of the export licenses. We, the defendant, have sold these licenses to the plaintiff. A dispute arose. Plaintiff came to us. Plaintiff paid us money, around 3.5 crores was paid to us as purchase price for the license. Dispute arose. Plaintiff came to the court. Plaintiff on the first day, which is page 7 of my supplementary affidavit.
Yes.
Page 7 took an order in terms of prayer B of the petition. Now, you will see that this is the order.
Prayer B of the petition.
Yes. Now, what is prayer B? If Lordships keep my petition side by side, because this is prayer B of GA 4059 of 1998.
So page?
Page, just give me 1 minute, man. This is page 24.
Yes. Page 24.
No, no, no. No.
Previous application.
No, yes, the earlier application, I'm at a budget. So she will give me 1 minute. Page 3 of my application. The application I have filed, which is
Yes,
IAGA
page
9.
3.
Page 3 of the application, I have quoted the prayers in GA 4059. Prayer B was an injunction. The next page, page 4. Prayer B was an injunction. Lordship can side by side, madam. So a prayer was allowed in terms of prayer B, which is an injunction on me from dealing with the licenses. Now, thereafter, what happened? This order was passed in November 1998. Now, in the supplementary affidavit,
That interim order is still today.
No, I'll just take it.
Yes.
That it is not there. Can I turn over to the page? Page 9. Sorry, page 8. This is an order of the supplementary. This is an order passed in the same GA application 4059 of December 1998 by Honorable Justice Sinha.
Page 8.
Page 8. Now I'll read this. It is stated that pursuant to the order
page
of
8 of your application.
No. Supplementary. Sorry, Mala. Supplementary. Because the orders were not with us, so we obtained the orders from the records of this court.
Yes.
It is stated pursuant to the order dated such and such passed by this court, Rashtriya Ispat Nigam Limited has returned the check of 3.22 crores in respect of the 3 outstanding licenses. The said check bearing number such and such dated such and such is produced to the court on behalf of the plaintiff. The learned advocate on record for the plaintiff deposit the said check, deposit check with ANZ Greenless in a short-term fixed deposit and keep the same renewed free of lien until further orders. This order is passed without prejudice to the contention of the plaintiff. So this order records that the consideration that the plaintiff has given to us, we have returned, and by pursuant to order of this court, this money is lying in the fixed deposit Standard Chartered Bank.
So the check which the plaintiff paid to you was not encashed.
No, it's the other way around.
No.
Plaintiff,
it is the check bearing is produced in court on yes.
I returned the money. Plaintiff paid the consideration to purchase the license. There was a dispute, so I returned the consideration.
Yes.
That money was kept in the fixed deposit.
Yes.
I'll come. This is not the fixed deposit today I'm asking. Because that money has gone to the plaintiff. The next order. Because I also got confused because then it becomes the plaintiff's money. Now the page 9. Page 9, here Lordship will kindly record in the top, another GA comes in, which is GA 4524 of 1999. So it's my GA. Now Lordship will see in my GA what prayer I have sought for. For that, in my application, Lordship will see page 24. We said, yes, I have annexed the GA. The general application starts at page 14.
Yes.
I said that these licenses had a shelf life. If you don't use the license within a particular time, it dies because of the central government policy.
Suppose the money was paid by you for the purpose of obtaining license.
I am the plaintiff.
No, you are not the plaintiff. You are the defendant.
I am the defendant.
So money was paid by the plaintiff to
me.
To you for the purpose of that license.
Purchase the license.
Yes. And that was not done. So it was for specific performance.
Yes.
So during the pendency of the suit for specific performance, you returned the check.
Yes, I returned the money.
Returned the money or just the check? The check was issued by the plaintiff.
The check was issued by the plaintiff. I returned the check.
You returned the check means what? That means you did not encash the check. Is it the position?
No.
The check is one thing.
That
means check issued by the plaintiff is returned means you did not encash the check. And you return the plaintiff's money, that is another thing. That means you encashed it, but
thereafter I returned.
Yes, so what is the order, language of the order?
Now let's come back to page 8.
Page 8.
Page 8. The order, what is recorded? I'll just place it once again. It is stated that pursuant
page 8 of supplementary
affidavit.
Yes. That pursuant to order.
Yes. Rashtriya Ispat has returned the check for 3.5 crores. So it means that I have not encashed.
Yes.
It means I have not. I have returned the check.
In respect of 3 outstanding licenses.
License. Those are the object, the product that they were purchasing.
Yes, the check number is also.
Check number is also mentioned, which is of 1998 only, of June 1998. So this money was then deposited with the bank.
Yes.
Obviously, the plaintiff did not want to accept the money because they have a specific performance case. They want the money to come to me. Now, Lordship will kindly come to page 9 of supplementary affidavit, the subsequent order. This order is passed in my application. By this time, I had filed an application which is GA 4524 seeking modification of the earlier orders.
Yes.
Now, I'll place this order, which is Justice Sengupta's order of 14th of March 2000.
Yes.
This is Kollanjudi Sengupta, not Ajit Sengupta.
Yes.
I was in the morning in court, I heard that.
No, 2000. Justice
Yes,
Ajit Sengupta
94.
Yes,
94.
retired. This is 2000.
Yes, that's 94. It appears that in terms of the earlier order dated 3rd of December, but 3rd December is the last page order, which I showed to your Lordship, the page 8. A sum of rupees 3.5 crores is lying deposited with the Endless Greenless Bank in a short-term fixed deposit. The advocate in record of the plaintiff is directed to encash the aforesaid fixed deposit prematurely, along with interest, and to hand over the said amount to Mr. Das's client. So here, the money goes back to the plaintiff. Mr. Das submits that his client has given instruction to take return of the aforesaid amount at his client's risk and cost so far as the pending suit is concerned. In view of the above matter, the earlier direction of 20th February 2000 is modified to the aforesaid extent. Parties to act on the signed copy of the order.
That means you see the check which was returned, there was a direction upon the plaintiff to
encash and take back the money.
Encash the fixed deposit prematurely along with interest.
Premature. So by this, the plaintiff took back the money that it paid as the consideration to purchase the license.
That is for the purpose of this contract.
Purpose of my lord.
Yes.
My lord. Then what happens? Then, my lord, the next page.
11.
Page 11. Then, Lord, she will kindly once again mark the application number. The application number is 4524. 4524 was my application, a copy I have annexed in my main petition. I said that you have to sell the license. Because if you don't sell the license immediately, the license will have no value. Because they have a period. So by this order of now comes another order of February 2000. This is quite a long order. Now I'll take your lordship the ordering portion, my lord.
I think this was the subsequent order. This
Yes,
March
yes,
14th.
yes.
So
Yes.
this is the previous order.
This is a previous one. Yes. This is 14th of March and this is the earlier one. So this 14th of March order records the fixed deposit in terms of 3rd of December. So it's the earlier fixed deposit. Now, on 22nd of February, this detailed order was passed by Justice Sengupta. Here, my lord. Now, Lord, she will kindly come to internal page 8 of the order after all reasonings. Internal page with the running page 18. Lord, you can skip over 3 lines from the top.
Yes.
So, the 3rd line. So, the whole intention of the plaintiff is not to to use. Yes.
Page 18, running page 18.
Yes. As such, the 3 lines from the top. As such, I think it fit in order to prevent the ends of justice being defeated, that the aforesaid 3 licenses should be sold at this stage pending disposal of the suit. However, such sale shall be held by the court. For this purpose, I appoint Mr. Such and Such, practicing advocate of this court, as the receiver to hold the sale by public auction to the highest bidder after advertising once in Economic Times and once in the Statesman. The receiver shall be paid a remuneration of such and such, and it continues. All eligible persons entitled to bid, and the receiver, and then it continues. The receiver is at liberty to stipulate the terms and condition of such sale upon deliberation and meeting of the parties. Accordingly, the defendant shall make over the original of the said 3 licenses forthwith to the said receiver. The licenses were with me, obviously. The receiver, after sale of the aforesaid 3 licenses, will deposit the sale proceeds thereof in a short-term fixed deposit in ANZ Greenless Bank. This is the second round. The first round is over. until further order of this court. The aforesaid proceeds will abide by the result of the suit. Till the receiver takes possession of the same, the defendant is restrained from alienating or transferring the same. The aforesaid free license, cost in the cause. In view of this judgment, the order in the application taken on Mr. Chatterjee's client is disposed of without passing any order. This was my application. This Chatterjee is the Oya Chatterjee for us. Mr. Das is who appearing for the plaintiff. Mr. Das, upon instruction, prays for stay of operation of the portion of this order which appoints the receiver. Mr. Chatterjee opposes the same. Having considered submissions made by the learned counsel, I am of the view that having regard to the urgency, stay of operation of the portion of this order which appoints the receiver is refused. Receiver shall take expeditious steps for holding sale consideration of the licenses with valueless after March 2020. So this was the reason, because the shelf life of the licenses were to expire on 31st of March. So that was the urgency to sell those licenses. In the event Mr. Das's client failed or neglected to bear the cost, that's the cost portion to advertise and other activities. So this is the order, my lord, by which the licenses were sold. And today the receiver, the personnel got changed. Receiver has filed a report. The receiver has filed a report before this court. Yes. Report Mr. Dotto, yes.
Receiver's report.
The receiver report. Yes. Yes. Now receiver, this so old a matter. So Mr. Dotto now, his report says that he still holds this money in the fixed deposit with, now the name of the bank has changed from Greenlace to Standard Chartered, and he confirms the figure which is in the paragraph 4 of the report. The fixed deposit confirmation advice is also given at page 5 of the report. So whatever the amount is there, my lord. So in this background, my lord.
That is total interest.
Total interest
The
is
principal is 55 crores.
So it's 5 crores,
50 lakhs.
5.50 lakhs.
5 crores, 50 lakh,
Yes,
33.
it is a 5.5 lakhs, 5.5 crores.
Yes, 5.5.
And with interest is around 6.5 crores.
So this is the amount which is lying in this
bank.
Now
there will be some
in the name of the receiver.
In the name of the receiver, she will see the maturity date. It has matured on 23rd of June. This becomes an auto renewal. Whatever is there.
Even there can be premature encashment.
Yes, Lord, she will see the money is held in the name of the receiver. In the CS number and the general application numbers are also mentioned in page 5.
Page 5.
5 in the top of the deposit number, and then in the name of
yes.
Mr. Dotto, receiver in CS number such and such of 1998, GA number 4059 and 4524, which is the present GA which we are looking at.
Anyway, in terms of the liberty granted by the court, see, first direction, the amount was, the check was returned to the plaintiff.
My lord.
And it was deposited by the plaintiff.
My lord.
Now the question is, so far with regard to these licenses, the licenses which expired on
March
2000.
2000.
Those were sold by the by the
office of the court. It's been sold by the office of the court, and then the money is lying with the bank. Now what happened, Malak? The plaintiff has now she will see the claims in the suit. Now today, why the plaintiff suddenly lost interest? In my application, I have set out the prayers. He had.
Let me see.
My application is there in the application.
Is there.
Plaintiff, the puji has. It's so bad.
There are older suits than 98 also.
No, the older suits I know, but those papers are coming to court daily.
Yes.
Here the papers are in the godown. That is the problem. If it is coming to court Delhi, then the termites and other things won't affect it.
Yes. Which page?
Page 2.
Page 2 of your supplementary affidavit.
No, no, of my petition only. Now,
Page 2. Yes.
today I am saying why the plaintiff has lost interest in the suit. He is seeking a defendant to specifically perform. Now, he has taken back his money of the consideration. The property is sold. So, any even prayer C can't be granted today because the licenses is no more, the licenses are no more available.
Directing the defendant to specifically perform the agreement.
For sale of the advanced licenses. So, the license has to be sold to them.
Has been.
Now, Lordship will turn over to the page. As the same are transferred and extended suitably. So, I have to transfer these licenses in favor of the plaintiff.
So, with regard to this, you see, the check which was paid by that was not encashed.
That was not encashed.
So, this is one thing.
So today the plaintiff, I'm on that. Why did not the plaintiff continue with the suit? Why did it?
That check was
returned.
No, second thereafter, before Justice Sengupta, the plaintiff appeared.
Before plaintiff appeared and the check was returned.
Prior to that.
Yes, prior to that.
In the March 2000.
Yes.
Another order was passed appointing a receiver. To sell.
Licenses.
And the money will be subject to the result
of the suit. Yes. So still to the suit is pending.
So, yes, suppose if the suit goes in favor of the plaintiff.
Yes.
That is one thing.
No. Now that's I am joining issue. Can the suit go in favor of the plaintiff in this situation?
Subject to the result of the
suit. Is it possible as on date for the court to pass decree for specific performance of some export licenses which was sold and which has expired in 25 years back? The licenses have expired 25 years back. Licenses are sold.
No, only thing is this plaintiff has remedy for damages. Nothing.
But they have not claimed. Yes. The only remedy is he has a remedy for damages. But he has taken back the money.
No, that is the purchase price.
Damages remains.
Damages
remains.
But that is why you see that observation was made. The license be sold.
Subject to the result.
Subject to the result of the suit. If the suit succeeds, that the acts of the defendant was bad and everything.
Damages.
At best damages.
But they were not claimed.
No, even if damages are not claimed, under the specific relief, it is empowered. Now the only thing is this.
Now this perpetual injunction is over. Because
money is lying with the receiver.
Yes, then his receiver.
If the suit fails,
subject to the result of this, the suit fails, the plaintiff is not willing to proceed with the suit. The money comes to me.
The money comes to.
Because
it was subject to the result of the suit.
Now I say the plaintiff has abandoned the suit.
Anyway, so
neither they are giving evidence, nor 23.
So at best, you see, for the purpose of dismissing this old suit, one administrative notice will go to the plaintiff. On that day, if they don't appear, I shall dismiss the suit.
Whatever.
And
that if that's the administrative protocol, that I can't come in the way.
The relief which you have claimed.
Yes. Now today I claim relief, my lord. Is that the receiver be directed to encash page 11, the encash the fixed deposits and transfer the money to me.
The plaintiff's lawyer as well as personally.
Not the lawyer, because the plaintiff's law firm has no more in operation. I've served the plaintiff is a company.
It came with the remark refused.
No, delivered. Affidavit of service. We have served them twice. I think we have served them twice because we have initially served at the address in the Costatl, which is at the Strand Road. 4th December, 6th January. There are 2 or 3 affidavit of service.
Record and order.
She will see these are delivered.
Yes.
And we obtained the new address from the Ministry of Corporate Affairs. Because there's a company.
So is it there in your Costatl?
No. Costatl address, they don't operate from the Costatl address. The Costatl address is in Strand Road. Now they have gone to Ita kothay. Ita to unno.
Because you see, administrative notices are served in the cause title, appearing in the plaint and in the plaint.
That we attempted to serve, my lord. Lordship will see. Yes, Lordship will see. This is the affidavit of service of 4th of December. 4th December affidavit of service. It was attempted to be served at the address in the cause title, which is as Strand Road. The envelope has returned.
Yes.
As per no such person in the address.
Okay, what is the current address?
Current address is available in the affidavit of service of May 2025.
Okay, May 2025. That is Baron Impex Limited.
Yes. Baron Impex.
31 Shakespeare Surrey.
Yes. This is the.
How did you get this address?
We got the address from the MCA portal that is recorded in the order. Yes, that is recorded in my lord's order of 30th April and giving me liberty to serve at the portal.
Yes.
Yeah, this is where we got my lord from the MCA portal.
I'm directing that necessary notice, administrative notice be served on that address.
Of the new address,
Yes.
right?
Mr. Mitro, learned advocate for the defendant, submits on GA 9 of 2024. Upon considering the applications and upon hearing the learned advocates, this court is of the view that one more notice, administrative notice, should be served upon the plaintiff at the address 31 Shakespeare Saroni, Jasmine Tower, 6th floor, Kolkata, 7,17,000, from where the plaintiff is operating its business. Let administrative notice be served upon the plaintiff and a report be submitted on or before 22/7/2025. Let this matter appear on 24/7/2025 at 4 p.m. Okay, 24/7 at 4 p.m.
4 p.m. Affidavit of service to the আমি তোমার সেই দিন affidavit of service টা ছেড়ে দিতে পারছো না যখন ছেড়ে দাও একটা affidavit of service দিতে পারছো না আজকে
affidavit of service fixed date.
Lordship, the next matter.
Yes, 4 p.m. matter, fixed matter.
Lordship,
Yes.
the next matter.
Yes.
Essentially, it was fixed yesterday.
Which case?
The next matter, 29. Yes, that is
completing his arguments.
Lordship, today, Lordship does
No, which case? Which case?
29, item number 29. May it be fixed on 7th, Lordship, because it was already fixed. That is the reason, and he will complete that. Let us have a civil discussion.
3 days. Well, they took 6 months to file AO.
Rashid, that is, if I had to delay, I would have not mentioned it.
I am suffering, my lord. I can't
If I
take
had
my
to
shop.
delay, I wouldn't have mentioned it. Too excited.
You should give prior notice in that case. Well, this time we are coming, my lord, we are coming prepared, and he is not coming prepared. On 21st of May, your lordship directed to submit written notes. On 21st of May, he was supposed to come with written notes, my lord.
7th,
My lord, he is not completing his argument, not submitting written notes. There must be an end to it.
Yes, you are praying for which date?
On 7th.
My lord, too late, my lord. Let it be kept on Monday. Yesterday, it was due to appear at 2 p.m.
Yes, we had taken time, I think.
Yesterday, it was fixed at 2 p.m., my lord. Let me be appear on Monday at 2 p.m.
Fixed matter আছে
My lord, any time at the earliest next week, my lord, or tomorrow.
Yes.
Tomorrow.
Tomorrow, fine, my lord.
কালকে 3 PM আছে এই 1 তারিখে হ্যাঁ 2 PM আর 10 তারিখে 2 PM
10. Any day after
anyway you come with your written notes. I shall conclude on 10th.
that, I mean,
And they were supposed to come on for written notes, my lord. Your lordship would
that
take it.
time will come.
Yes, record an order.
They were supposed to come with written notes on 16th of
Right.
June, my lord.
Advocates for the parties are present. Let this matter appear on
তোমার হজম পুরো বের করে দাও।
10/7/2025 at 2 PM. Huh?
I'm ready.
My lord, your lordship reflects on, my lord, this is continuing for long. My lord, since 2013, I am supposed to get back my possession.
Now it
Tenant
will-
the person has expired.
Now it will not take much time. It is only hearing of this application.
That's right, my lord, but hearing, my lord, that too, 4 days already gone, my lord.
Anyway,
And every time 3 weeks time is given to them. Every time 3 weeks.
The other dates have fixed matters. I wanted to, if you want the matter to remain in the list in the usual course, I can keep it. But as because I am fixing the matter, I am keeping it on 10th.
My lord, your lordship would keep it on Monday.
But I don't know whether the court can reach that position or not. That is why I fixed the matter on 2 PM on 10th.
Yesterday it was there for at 2 PM. Unfortunately, your lordship
Anyway,
didn't say it, my lord.
that is why again I have kept it at 2 PM on 10th. Yes, call the next. Yes, 4 PM matter. Yes, I think a report was called for and I granted you liberty to obtain a certificate.
My lord, and there was direction to the department to provide.
So have you, no, department was directed.
I applied for, but they said it has been sent to my lord. They will not give copy to me.
My lord, I am interrupting for some. Then in that case, written notes be served upon me, so that I can also come prepared with the written notes. I would inform them if necessary. Advance copy of the written notes be served upon me.
Actually, I see in their presence I have passed an order.
I will inform them. I undertake. I will inform them.
আচ্ছা ওখানে একটা লিখে দেবেন তো একটা জায়গায় let written notes of arguments be
The
exchanged.
defendant be served upon
Written
the
notes of arguments be exchanged in the meantime.
Your lordship would fix the dates. Otherwise, they would.
I fixed it on 10th.
But for submitting written notes to me, my lord. Because
I have said written notes of arguments be exchanged in the meantime.
What is it? Your report, I believe, it has been sent by the department to the my lord's officer.
Take a report. Yes, there is a report that in terms of the order passed by this court on 26/11/2014 for affixation and publication of general citation as well as special citation, no affidavit of service is filed. Thereafter, affidavit of service regarding special citation for publication upon legal heirs of deceased, which was issued by this registry on 12/6/15 in compliance of the order dated 28/4/2015, has not yet been filed in the department. Affidavit of service. Then again on 22/6/18 there was an order regarding issuance of special citation for wall affixation at the last known address of the legal heirs, namely Srimati Chandrolekha Jain and Srimati Shashikola Chennai, but no affidavit of service was there. So these are the defects which is to be complied with. Then, although no caveat is there, Because in the absence of these affidavits, the department.
Lord, I don't know. I have given a bunch of papers which is annexed there. It were filed.
No, but the report is that you have not filed.
10 years back it was filed.
No, the report is that no affidavit of service in respect of affixation has been filed. It is the report that it is not filed.
But I have not, the 12/6, I filed the affidavit service. I have a copy of in the bunch of papers. It is there.
When did you file? 12/6 of?
I'll tell you. Lord, the special citation is page 41. Then service on 4th February 2017. 4th February 2017. Then there are 3-4 orders. Then again, Lord, 5th June 18. I filed another service.
Yes, from where do we get that? From where?
I'm Lord. Kindly see, Lord, page 54 of the petition.
Hey, petition 54. Petition ta dekhi.
Upon by one.
Which petition? GA?
Lord, petition, Lord, PLA.
No, PLA. What is that affidavit of service which you are required to file?
Page 43, kindly see. Devashish Mujumdar, one affidavit service.
No, page 43. Which page? No, it is not here.
It is there. May I find out from the record, by my lord's record? All affidavits are there. The one is this, then other affidavits in 17. This is publication in the newspaper.
Okay, this is dated.
So can you see the first the back seat?
Okay.
I believe
4th February 2017.
They have not taken up the record. Then 5th June 17, the third service about this. As you see, all the affidavits are there in the record, my lord's record. I think department has not looked into it. There are 4 affidavits are there, service. The special citation, general citation, paper publication, all formalities were done, all formalities.
Yes, record and order. Learned advocate for the petitioner is present. A report is received from the registrar in insolvency stating that no affidavit of service in respect of affixation of general citation has been filed in the department in terms of order dated 26/11/2014, and no affidavit of service regarding special citation for publication upon legal heirs of the deceased which was issued by the registry on 12/6/2015 in compliance of an order dated 28/4/2015 passed by this court has not yet been filed in the department. And lastly, no affidavit of service has been filed with regard to issuance of special citation for wall affixation at the last known address of the legal heirs, namely Srimati Chandrolekha Jain and Srimati Shoshikola Chanani, is filed, for which certificate for which no caveat certificate cannot be issued. Learned advocate draws attention to the affidavit of service affirmed by Sanjay Pandey on 5th day of June 2017. Affidavit of service affirmed by Sumitra Devi. Affidavit of service affirmed on
The last page.
4th day of January 2018 by Vijay Thakur. Affidavit of service affirmed by Devashish Mujumdar on 4th day of February 2017. Affidavit of service affirmed by Nitin Daga on 7th February 2017 are on record. Stop. Thus, the department is directed to ascertain as to whether a caveat has been lodged in the instant probate case. Let such report with regard to lodging of caveat be submitted on or before 11/10/2025, 11/7/2025. Let this matter appear on 16/7/2025 at 4 p.m.
May I, my lord, send my clerk to the department to sort it out whether which is not there and which is there.
No, I think the records are to be sent then for before the department.
Yes. Kindly give me leave, my lord, to just assess the department to find out the affidavit.
Yes, learned advocate shall extend necessary cooperation
Find out the
to the department. আর আজকে 4 PM ম্যাটার কিছু ফিক্স আছে? ঠিক আছে, তাহলে ইয়ে করে পাঠিয়ে দিতে বলো। Yes, any extreme urgent matter?
But next matter, my lord, I am appearing, my lord. My lord, it's an injunction application, my lord. I was beseeching you, lord, my union is there, my lord. There is an injunction order, my lord, which we are enjoying in respect of a property.
No, which one?
Item 30, my lord. Item 30.
What, 30?
30.
Okay.
Guinea Devi time wala, but sir, our Santi Lal.
Okay.
Now, today I find someone is appearing for defendant also, my lord. One of the defendants.
30.
And for, yes, my lord.
30.
Number 5, my lord, I'm filing my affidavit in reply to the GA1.
Yes, item 30.
It should be, my lord, opposition, not the reply.
Item 30 ta call kore di.
I appear for the plaintiff. My lord, may I be given to file affidavit in opposition?
This is affidavit in opposition. Yes, record an order.
No, I shall file my reply.
Learned advocate for the plaintiff and learned advocate for the defendant number?
5, my lord.
5 is present. Let affidavit in opposition filed by defendant number 5 in GA1 of 2012 be kept with the record. Affidavit in reply.
My lord. 2 weeks time, my lord. They are from Karnataka, my lord. I have to get it from there. Or 3 weeks, my lord. That would be better.
11/7/2025. Let this
Little more time.
Yes, 11/7.
That will be, my lord, you have to give us 3 weeks time, my lord. You have to send it to Bellary, my lord.
18/7/2025. This matter appear on 22nd July 2025.
And deeply obliged. Simply ordered to continue, my lord.
Interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
It is until further orders is continuing.
For
Already
5
continued.
further orders.
Very good.
If my lord, can we take item number 32?
I'm deeply obliged.
31, my lord.
31. What is the urgency?
My lord, this is a suit for partition, my lord.
It is a hearing matter. It will take some time.
It's not a hearing matter, lord.
Yes.
My lord, the partition commissioner was appointed, my lord, and partition commissioner was directed to file a report by 19th of June, my lord. My lord, we are praying for extension of time to file the report, my lord. Let the
Talks of my lord, partition is still going on, lordship. They will require some time. My lord, kindly extend that.
extend the time to file the report by.
Yes, item 31. Learned advocate for?
I am for the plaintiff, lord.
Plaintiff and learned advocate for the defendant are present. today was fixed for filing report by the Partition Commissioner. However, as the report could not be made ready.
My lord, the inspection has to be done. My lord, the initial meetings have
Yes,
been
as
conducted.
because the inspection could not be completed.
Yes.
The time to complete the inspection and submit the report stands extended till 21/7/2025, 21st of July.
Lordship will keep it in the month of August, my lord.
First week of August, my lord.
Okay. 30th July 2025.
Lordship.
Let this matter appear on 2nd August 2025. It's a Saturday and a working day. Okay.
Oh,
Working
yes.
day, Saturday, no problem.
Lordship, one thing, my lord. My lord, in the last order, my lord, this the partition commissioner has been termed as the special officer. It has to be the partition commissioner.
Okay, on the next day, I shall see. After all, he is also a special officer.
Yes, my lord.
Officer appointed by the court.
Yes,
He is all
definitely.
status is of the special officer.
Yes.
Let us see on the next day. I shall clarify that.
So great.
Okay, 2nd August.
Second, Saturday.